All right, good morning, everybody. It is, what day is it? It is January 13th, 2022, and it is 9:06 a.m. And this is a regularly scheduled meeting of the Oil Conservation Commission. I'm Adrienne Sandoval. I am Chair of the Oil Conservation Commission and Director of the Oil Conservation Division. Also with us today are our two other commissioners who will be doing the first part of this agenda, and then we will do a further introduction for the back half of the agenda. But Commissioner Bloom, would you please introduce yourself?
Thank you, Madam Chair. My name is Greg Bloom. I'm the designee of the Commissioner of Public Lands, Stephanie Garcia.
And Commissioner Warnell.
I'm sorry, I don't know what went on there because I could hear him before. I was all muffled on that last part. This is Chris Bloom. I know what you said, but
I'll repeat, sure. Yeah, my name is Greg Bloom, and I'm the designee of the Commissioner of Public Lands, Stephanie Garcia.
Thank you. Commissioner Warnell, would you please introduce yourself for the record?
Yes, Madam Chair. Good morning, everyone. Terry Warnell, designee for the Secretary of IMNERD.
Thank you. All right. First item on the agenda is approval of the agenda. Commissioners, have you reviewed the agenda, and is there a motion to approve?
Madam Chair, I move to approve the agenda.
Madam Chair, I second that motion.
Mr. Moander, would you please do a roll call vote?
Yes, Madam Chair. Commissioner Bloom.
Approved.
Commissioner Warnell.
Approved.
Madam Chair.
Approved.
The motion carries.
All right, on to agenda item number 3, approval of the December 17th, 2021 meeting minutes. Commissioners, have you reviewed the minutes, and is there a motion to approve them?
Yes, I was able to review the minutes, and I move to approve the minutes of the last meeting.
I'm sorry,
Chair?
I'm not getting, am I the only one that's not getting any sound from?
No, it's like it starts off strong, Greg, and then it like disappears.
Okay. We'll try it again. Yes, I did read the minutes from the last meeting, and I move to approve them.
That was good. Thank you.
Madam Chair, I also read the minutes of the last meeting and second that motion.
Mr. Moander, would you do a roll call vote, please?
Absolutely, Madam Chair. Commissioner Bloom.
Approved.
Commissioner Warnell.
Approved.
Madam Chair.
Approved.
The motion carries.
Next item on the agenda is entry of adoption of the order in case number 22225, which was application of the Energy, Minerals, and Natural Resources Department, Oil Conservation Division for proposed amendments to the Oil Conservation Commission's rules on natural gas gathering systems in 1915-28 INMAC. Commissioners, have you reviewed the order that was circulated? And is there a motion to adopt the order?
Madam Chair, yes, I was able to review the order, and I move to approve the order.
Is there any discussion on the order?
Madam Chair, discussion would be proper after a second to Commissioner Bloom's motion.
My bad. Is there a second?
Madam Chair, I second that motion.
Now, is there discussion on the order in case number 22225?
Madam Chair, I do not have anything that I need to discuss. The order looks excellent to me. Thank you.
Madam Chair, I have nothing to discuss. Having read the order, it looks good to me.
Thank you. I have reviewed the order in case 22225, and it represents what was discussed at rulemaking hearing on December 17th and meets the intent of the commission. So with that, Mr. Moander, would you please do a roll call vote?
Yes, Madam Chair. Commissioner Bloom,
Approve.
Commissioner Warnell,
Approved.
and Madam Chair,
Approved.
the motion carries.
Thank
I would
you.
ask that everyone today, if you can, you just need, if you would submit your signature on the final page, so we can get, even if it's in triplicate, that's acceptable. That's what I usually do, but please try to address that today if you would.
Thank you, Mr. Moander. Next item on the agenda is agenda item number 5, update on case number 21872. Application of Titus Oil and Gas Production for approval of production allocation. During our last hearing on that case back in 2021, there was, as part of the decision in that case, a requirement for the division to provide an update to the commission quarterly beginning in January, so today. And with that, is there a representative from the division today to provide an update on the status?
Madam Chair, I'm here on behalf of the division to provide an update on the discussions. My name is Dylan Fuge. I'm the General Counsel of the Energy, Minerals, and Natural Resources Department. My report today is pretty simple. You know, we've made some outreach attempts to the state of Texas. Madam Chair, you reached out in your capacity as the director of the Oil and Conservation Division a couple of times to your counterpart at the Texas Railroad Commission. I've done similar outreach to my counterparts at the Texas Railroad Commission, including having a sort of preliminary discussions with them at the November meeting of the IOGCC. Unfortunately, those discussions have not resulted in any response from the Railroad Commission. And so we continue to wait for some direct engagement from them before we can, you know, make any forward progress on an MOA. And I'm happy to address any questions by the commission.
Thank you. Commissioners, do you have any questions regarding this matter?
Madam Chair, I do not have any questions. It's just unfortunate that we haven't seen the engagement we need from the Texas Railroad Commission on this.
Questions, Madam Chair?
Thank you. I have no further questions either. Thank you, Mr. Fuge, for your time this morning, and I guess we will see you back April?
Yeah, that's my expectation. Thank you.
Thank you. Ms. Davidson, just please make a note that we need to ensure that that's on the next docket or the April docket. All right. And with that, I believe Mr. Impoma, or I'm sorry, Dr. Impoma will be joining us for agenda item number 6 in case number 21324, de novo case number 21902. Thank you, Commissioner Warnell, for your time today.
Yes, we appreciate having had you on the commission. It's been a pleasure.
Well, thank you all very much. It's been a pleasure for me also. I appreciate all that you've done.
Thank
and wish you the best of luck.
Thank you, Commissioner Warnell.
Thank you, Greg.
Dr. Impoma, would you please introduce yourself for the record as well as probably spell your name for the court reporter so she ensures it's correct?
I am Dr. William Ampoma, William W-I-L-L-I-A-M, Ampoma A-M-P-O-M-A-H. I am a professor at Tech and also a designee of the Energy Secretary.
Thank you, Dr. Impoma. All right, well, let's proceed on agenda item number 6. Again, that was case number 21324. Do we have, let's see, both of the, I see Ms. Shaheen is I do not see the other party. Mr. Bruce, are you on?
Madam Chair, Mr. Bruce usually participates by telephone, so I don't know if you have
Oh.
anyone.
There's one call-in user. Let me unmute. I
Yes,
just
this is-
unmuted. Okay, there we go.
Yeah, this is Jim Bruce, and I'm not set up for video, so I'm doing this by phone.
Okay,
Th-
well, I
thank you.
cannot make you a panelist, but I can just leave you unmuted, which means you're going to have to mute and unmute yourself.
Yeah, I do that regularly at the division. Thank you.
Okay, great. All right. Well, with that, so the applicant, Mr. Tom Ragsdale, and then Mewborn, it looks like you're both here. Ms. Shaheen, would you like to make a brief opening statement on behalf of your client?
Yes, thank you, Madam Chair. Sharon Shaheen on behalf of Tom M. Ragsdale. And I would just note in the beginning that Mr. Ragsdale is on his way to my office to participate in the hearing. I thought it might be helpful. I'm hoping that everyone got the exhibits that the parties submitted. And I thought it might be helpful for us just to take a look at what we have in the exhibits to get started. Would that be acceptable?
Do you need to share screen? Is that what you're asking? Okay,
Yes, I would like to share screen
let me,
if I can figure that out.
yeah, let me, you should be able to now or shortly.
Okay. Yep, looks like that I can. Can everyone see that?
Yes, if you could make it maybe a smidge bigger, that would be helpful.
How's that?
Better,
Good.
thank you.
Mr. Ragsdale submitted a pre-hearing statement, and attached to that pre-hearing statement was a list of material facts that are not in dispute that we had previously submitted to the division. We have since revised that set of material facts, and it was filed yesterday and submitted to the commission yesterday. So we would refer you to those lists of undisputed facts. Also attached to the pre-hearing statement is Mr. Ragsdale's direct testimony and his exhibits. His exhibits are exhibits 1 through 10. And I will attempt, as we go through today's hearing, to share my screen and direct you to the PDF page numbers as well, if that would be helpful. And then Mewburn's
Ms.
exhibit.
Shaheen, sorry, I'm going to interrupt you just real quick. You said you filed this yesterday.
Well, we filed the exhibits a week ago.
The updated versions you filed yesterday.
The updated version of the undisputed facts. The parties conferred over the past week and reached agreement on a revised set of undisputed facts. And Mr. Bruce, please weigh in if you'd like.
No need to at this time.
Ms. Davidson, I think you tried to forward this maybe this morning, but I don't see the attachment.
Madam Chair, I can forward those to you right now.
Thank you. Maybe I'm the only one missing them. Oh. Maybe not. Okay, thanks. Go ahead.
Thank you. So getting back to my opening argument, Mr. Ragsdale asked that the force pooling order numbers 20894, 20894-A be revoked, or in the alternative, certain well costs that were imposed by Mewburn be declared unreasonable. The bottom line is Mewburn imposed the cost of 2 failed attempts to drill 1 well that were incurred prior to a forced pooling order being issued and prior to Mr. Ragsdale having an opportunity to elect to participate. Mewburn is imposing those costs of drilling on a different well. The first well that they attempted to drill, we call the 1015-2H. The well that they imputed the cost for the failed attempts to drill the 1015-2H were imposed, they were shoehorned into the estimated costs for drilling the 1510-2H. Mewburn included $3.1 million worth of additional cost for those 2 failed attempts in the AFE that it delivered to Mr. Ragsdale with the pooling order. Mewburn's actions are contrary to the express provisions of 19.15.13.8b NMAC regarding well costs. These wells relate to 2 previous forced pooling cases. The first one is 20580 that addressed what we call the 1015 wells. 20809 addressed the 1510 wells. Mewburn failed to provide notice of its intent with respect to case number 20809, the latter case, in accordance with 19.15.4.9A6 NMAC, and thus violated Mr. Ragsdale's right to due process under the Uden and Johnson cases. Ultimately, order number 20894-A superseded order number 20894 and pooled all 4 wells. It pooled 2 1015 wells and 2 1510 wells. Most, if not all, of the material facts appear to be undisputed. There may be some inconsistencies between the written testimony and the statement of undisputed material facts. I think we may have cleared that up, but if not, we'll clear it up in testimony today. Most of the facts will come out during the testimony or they're already set forth in the undisputed facts, but I would like to point out a few key facts at the outset. Mr. Ragsdale never had the opportunity to elect to participate in the 1015-2H wells under either forced pooling order. Mr. Ragsdale never received a copy of order number 20924 in case number 20580. Mewburn never informed the division, nor Mr. Ragsdale, of its intent to impose the cost of 2 failed attempts to drill the 1015-2H on the cost to drill the 1510-2H. Mewburn's application in case number 20809 did not state that it would seek to pool the 1015 and the 1510 wells in one order, and Mr. Ragsdale never had notice of Mewburn's intent in this regard. The notice letter regarding that case did not provide that information either. The AFE that was submitted for the 1510-2H to the division in case number 20809 did not include the cost for those failed attempts to drill the 1015-2H. Mr. Ragsdale did not know until he received Mewburn's election letter on March 11, 2020, that Mewburn intended to collect those actual costs for the 1015-2H failed attempts as estimated cost for the 1510-2H. Mewburn's attempts to shoehorn the costs of two failed efforts to drill the 1015-2H onto the estimated costs of the 1510-2H are improper under these circumstances. Mewburn took a business risk when it drilled prior to getting a forced pooling order and providing Mr. Ragsdale with an opportunity to elect to participate. Mewburn should be held accountable. And with that, if I could take a second to double check whether my witness is online. He was unable to join through the panelist.
I show him online.
Oh, good. Let me see if let me just double check
But
here.
before we go to witnesses, I would like to hear if Mr. Bruce has an opening statement.
Oh, yes. My apologies for that.
Mr. Bruce?
Yeah, very, very briefly, Madam Chair. These wells involve the east half of sections 10 and 15 in the pertinent township and range. Mewburn has drilled many wells in this area. when they attempted to drill the 1015 B1 well, they hit an impermeable barrier, and so they moved the rig and drilled from that location. Again, they hit an impermeable barrier, and that's where the $3 million in costs was incurred that Mr. Ragsdale is complaining about. Fact of the matter is, Ms. Shaheen said he never had a chance to join in the well. If he had, when the order came out, would there have been any difference in the outcome? Getting a sooner election period would not have cured the incurring of the $3 million in costs for that well. Moreover, what the division does when it pools an interest, they pool the well unit, not the particular wells. And what happened was, once the first two attempts to drill below this impermeable barrier occurred, Mewburn decided to flip the surface locations. Instead of drilling from the north to the south, flip it to the south to the north, which was a prudent move because they drilled the well successfully and completed it, and the well is producing. The division regulations provide for a substitute well, and that's what this is. And I put this forth because it's a substitute well. Anything for the original wells, those costs should be imputed to the substitute well. And what if, just in drilling the first well, the very first attempt to drill the well, what if Mewburn had hit that impermeable barrier, but decided to keep on drilling, and they had to spend another $3 or $4 million just to drill that well to get it through the impermeable barrier? Would those costs have been reasonably assessed against the working interest owners for that 1015 well? I believe they would be. So since the division held that the 1510 well, the one well we're here for today, was a substitute well under division well regulations and under general practices in the business, those $3 million are imputed to the well which was successfully drilled. And I would point out that there are a lot of interest owners in this well. Mr. Ragsdale was treated like all of the other interest owners, dozens of them, and none of them have raised any issue with respect to the well costs. We believe that Mewburn acted properly, drilled a good well, and that Mr. Ragsdale's complaint should be dismissed. Thank you.
Thank you, Mr. Bruce. Ms. Shaheen, would you like to call your first witness?
Madam Chair, could I take just a minute to call him on the phone because I'm not seeing him in the room there?
Who is it?
Mr. Ragsdale?
Mr. Ragsdale is listed here as a panelist on my screen.
I see that our conference room is represented there for Mr. Ragsdale, but I don't see Mr. Ragsdale in the room.
Gotcha.
So
Okay.
do you mind? I apologize. Let me just double check about his
Go ahead.
whereabouts. Okay, thank you. My apologies, Madam Chair. He's in the parking lot. So he's walking up to the room now. It may be helpful for us to talk briefly about how the commission would like for us to present the written testimony. We can walk through the written testimony if you like, or we can simply go through the preliminaries of having that written testimony accepted into the record. Mr. Bruce may want to weigh in on his preference there, but I thought we should ask what you prefer.
Mr. Bruce, do you have anything to state on that?
Well, I was planning on introducing my witnesses, asking them to adopt their written testimony, but I would like the chance to ask them some questions up front and then turn it over to Ms. Shaheen and, of course, the commission.
Ms. Shaheen, do you have a response?
That's acceptable to me. I don't know that I have, that I'll have many questions for Mr. Ragsdale other than what's in his written testimony, but we'll walk through it briefly.
Commissioners, do you have any questions regarding that? Commissioner Bloom?
I do not, Madam Chair, no.
Dr. Ampoma?
Yeah, Madam Chair, it would be good if they can walk through so I can follow.
Okay. So for the written testimony, we need to obviously introduce it for the record, get it entered in as an exhibit. I think that we should, if you're not going to do additional questions or cover pieces of it, at least kind of summarize it. We don't need to go through it word by word. We have it in written form, but at least provide an overview of the testimony.
I will make an effort to do that efficiently.
All right, should we just maybe go ahead and take like a brief 5-minute break, let Mr. Ragsdale get together? So why don't we come back? It's 9:33 right now. Why don't we come back at 9:38? Do you think that's enough time, Ms. Shaheen?
It should not take him more than 5 minutes to get from the parking lot to the office.
Okay, great. So we'll come back at 9:38.
Okay, thank you.
All right, Mary, are you there?
Yes, I am.
Okay. All right, Ms. Shaheen, will you please introduce your first witness for the record?
Thank you, Madam Chair. Tom M. Ragsdale on behalf of himself. And I'm going to share my screen once again so we can all just see his testimony as we walk through it.
Ms. McFarland, would you please swear in the witness?
Yes. Mr. Ragsdale, would you raise your right hand, please? I can't see him. Do you solemnly swear under penalty of law the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
Yes.
Thank you.
Good morning, Mr. Ragsdale. Can you see the screen that's in front of you? It should be your direct testimony. Do you see that?
Yes, I do.
Okay, can you please state your full name for the record?
Tom M. Ragsdale.
And you're the applicant in this case, is that right?
Yes.
And what is your occupation?
I'm a petroleum engineer.
Please describe your education and work experience briefly.
I received a petroleum engineering degree from Texas A&M in 1985. My work experience since that time is as follows. I've worked for a South Louisiana drilling company, Gray Wolf Drilling Company, in 1985 and 86, and a Louisiana production company, Petroleum Engineers, Inc., in 1987. I then worked for IP Petroleum, a wholly owned subsidiary of International Paper, for approximately 3 years. Thereafter, I worked for Meridian Oil for approximately 1 year, and I then went to work for Costilla Petroleum for several years. And beginning in 1992, I worked as an independent consultant for a couple of years, 2 years, I then started Cian Oil and Gas in 1994. In 1996, Ciana began contract operating in New Mexico. In 1998, I started acquiring and managing minerals in New Mexico. I have managed minerals in New Mexico since that time.
So is it fair to say that you've been in the business for about 35 years?
Yes, I believe so.
And I would ask now that Mr. Ragsdale be admitted as an expert witness in this matter and that his direct testimony be admitted into the record.
No objection, Madam Chair.
Commissioners, do you have any questions regarding the exhibits or concerns about entering them into the record?
Madam Chair.
No, Madam Chair.
Do we need to take a vote for this, Mr. Melander, to enter them into the record? Can't remember.
I'm sorry, what was that, Madam Chair?
To enter exhibits into the record, do we need to take a vote?
No, you've got the power to do the admission
Okay, great.
into the record.
The exhibits are entered into the record.
Thank you, Madam Chair. Taking a look at your direct testimony, Mr. Ragsdale, let's just briefly walk through it. You own the mineral interest that's at issue in this proceeding. Is that correct?
Yes.
And what is the nature of that interest?
I own approximately 4.89% working interest in the spacing units and wells at issue in this proceeding.
And it's your understanding that there are undisputed facts in this case, right? And we've submitted a revised set of undisputed facts. And is that correct?
I believe so. Mewburn and I agreed to a number of undisputed facts that were submitted in this case before the division. I also submitted the same set of undisputed facts to the commission as an attachment to my pre-hearing statement in this proceeding before the commission.
And that the first set was previously submitted to the division. Is that correct?
I believe so. Yes.
And the revised statement is statement of facts is the operative statement of facts at this time. Is that correct?
I believe so. Yes.
Here in your testimony here, you describe the lands and the wells at issue. Can you briefly describe the lands and wells at issue for the commission?
In case number 20580, order number R20924, pooled the Bone Spring Formation underlying the east half of sections 10 and 15, Township 23 South, Range 34 East, New Mexico in Lee County, New Mexico, for the purpose of drilling the IBEX 1015 B1 AP Fed Com well number 2H, API number 30.02546.188, parentheses 10-15 2H, and the IBEX 1015 B3 AP Fed Com well number 1H, API number 30.02546.189, parentheses 1015 1H. It's
And
collectively.
I'm sorry, in this case, we're concerned with the 1015 2H, correct?
Correct.
And in case number 20809, order number 20924-A pooled the same unit, correct?
Correct.
And they did that for the purpose of drilling what we call the 1510 2H, is that correct?
Yes.
And please explain to the commission the issue in this proceeding.
The issue is whether Mewburn can allocate cost for the failed attempts to drill the 1015 1H and a substitute well, the IBEX 1015 B1 AP FedCom number 2Y, which were incurred prior to any related force pooling order. In Mewburn's estimated cost to drill the 1510 2H.
And you did not enter an appearance in the first case, right, regarding the 1015 wells, is that right?
Did not. We did not object to the wells as proposed by Mewburn in its well proposals, applications, and the related notice letter. Entering an appearance was therefore unnecessary.
And what happened after that?
Prior to an order being issued in case number 20580, Mewburn made 2 failed attempts to drill the 1015-2H. Subsequently, and again prior to an order being issued in case number 20580, Mewburn filed its application in case number 20809, seeking to force pool the same lands, but for the purpose of drilling the 15-10 wells.
Did you receive a well proposal for case number 20809?
I did not.
Did you enter an appearance in that case?
Did not.
Why not?
My review of the filings in that matter, as well as the resulting order, indicate that it is the case.
Let me clarify. You did not seek to enter an appearance in case number 20809, which is the second case. Is that right?
Yes, that's right.
And you didn't object to the wells that were proposed by Mewburn in case number 20809. Is that right?
Yes, that's right.
So there was no need to enter an appearance.
That's correct. There was no need to.
And when you received the notice letter in the application for case number 20809, did it say anything about pooling 4 wells, or was it only seeking to pool 2 wells?
Only seeking to pool 2 wells.
And at any time, were you informed by Mewburn that they intended to force pool the 1015 wells and the 1510 wells in the same pooling order?
No, we were not.
And at any time, did Mewburn inform you that by electing to participate in the 1510 wells, you were committing yourself to pay the actual costs for 2 failed attempts to drill the 1015-2H?
No, they did not.
When did you learn that Mewburn considered the 1510 wells to be, quote, substitute wells for the 1015 wells?
When we received an AFE from them that had some inflated cost that appeared to include the failed 2 drilling attempts to drill the prior wells on our AFEs.
And you were a few days late in returning those executed AFEs, is that right? For the 1510 wells?
We may have been, but I believe we were challenging those costs. And there were some other circumstances as well.
Now, here let's just briefly run through this about the exhibits that are attached to your testimony. Exhibit 1, can you tell the commission what's there in Exhibit 1?
Exhibit 1 contains maps that were submitted by Mewburn in support of its applications in case number 20809. The first page indicates the separate locations of each of the 4 wells that were pooled in case number 20809. The second page shows the locations of the 1015-1H as compared to the 1510-1H, and the third page shows the locations of the 1015-2H as compared to the 1510-2H.
Let's take a minute. I'm going to take us to PDF page 22. This is the third page that shows the locations of the 1015-2H as compared to the 1510-2H. Does everyone see that map there?
Yes.
And Mr. Ragsdale, can you describe what is here on the map?
The map, my understanding is it shows 2 wells, and one well is going to be oriented from the north to the south, and the second well will be oriented from the south to the north, just opposing directions.
And is it your opinion those completed laterals are really, they converge at one end, but they're not in the same in the same location, correct?
That's correct.
And going back to your testimony, see if I can get back to the right page. I'm close. Turning to Exhibit 2, can you explain briefly to the commission what is in Exhibit 2?
This exhibit includes the C102s for the 1015-2H and the 1510-2H that were submitted by Mewburn to the division in case numbers 20580 and 20809.
And is there any indication on Exhibit 2, and I can take us there. Let me try to do that. That indicate Mewburn intended to drill the 1510-2H as a so-called substitute or replacement well for the 1015-2H, and I'm going to take us to those C102s, I believe. Here we go. So here is the 1015-2H, and I'll turn now to the 1510-2H. Is there any indication on the C102, I'm going to make it just a little smaller, that Mewburn intended to use this, to drill this well as a substitute well for the 1015-2H?
No, there is not.
Going on.
Sorry, Ms. Shaheen, Madam Chair, may I interrupt with a clarifying question?
Yes, please.
Commissioner Bloom, can we hold the questions until after Mr. Ragsdale has finished his testimony?
That's fine, thanks.
Turning to applicants' exhibits 3 and 4, can you describe these exhibits?
Yes, these exhibits consist of the exhibits that were submitted by Mewburn to the division in case numbers 20580 and 20809, respectively, including the verified statements of Mr. Robb, who is Mewburn's landman.
And is there any indication in those two exhibits that Mewburn intended to drill the 1510-2H as a so-called substitute well for the 1015-2H?
No, there is not.
Turning to applicants' exhibit 5, can you describe this exhibit briefly?
Exhibit 5 is a letter election notice from Mitch Robb at Mewburn to myself, dated March 5th, 2020, to which is attached a revised AFE for the 1510-2H, which was revised to include the cost of the failed attempts, the 2 attempts, to drill the 1015-2H.
Okay, and I am going to try to take us to that AFE just so we can all take a first look at it. And I'll make it a little bigger here. We'll come back to this with Mewburn's witnesses, but can you indicate to the commission where the inflated cost is reflected?
Most of the inflated costs are on the drilling intangible side. That one column.
Is that here? Can you see my cursor, the little hand?
Yes, I can. It has TCP, which means 2 casing point, and those costs are greatly inflated over the other normal regular AFE.
And you've tried to do the math with respect to some of these numbers, is that right?
Yes, we have.
Is the math, is the correct math reflected here in the TCP column?
No, it does not.
And so just scrolling down, I'll scroll down here to the bottom of the page. And what was the total well cost for this 1510-2H?
The total on this AFE is 12.49, 12 million, approximately 12.5 million.
And how does that differ from the AFE that was submitted to the division in case number 20809?
It differs in the sense that it's approximately 34% higher, about $3 million higher than the one they submitted to the division or the commission, about $3 million higher, 34% higher.
Okay, moving on to Exhibit 6. Can you describe to us what Exhibit 6 is?
Exhibit 6 is an email chain dated March 11th, 2020, between our landman Karen Stanford and Mitch Robb of Mewburn. This email chain reflects the questions that I and Ms. Stanford had about the cost for the previous failed drilling attempts imposed on the estimated cost for the 1510 2H.
And before we look at Exhibit 6, I want to take us there. But just to clarify, Ms. Stanford was employed at that time as a contract landman for your company, Sienna Oil and Gas. Is that right?
Yes,
And you are the sole proprietor of Sienna Oil and Gas, correct?
yes,
And at
that
the
is
time-
correct.
And at the time she was communicating with Mr. Robb, she was acting on your behalf. Is that right?
Yes, it is.
Let me take us to Exhibit 7. And I'll start at the bottom of the page because I believe these are in reverse chron order. The bottom email dated March 11th, 2020. Do you see that?
Yes, I do.
And is Ms. Stanford reaching out to Mr. Robb because Mewburn didn't send the order with the election letter? Is that right?
Yes, that's correct.
And then Mr. Robb does respond pretty quickly, sends her the order. That's in the this next email dated March 11th, 2020 at 5:38 p.m. Do you see that?
Yes, I do.
And then here, this final email is from Ms. Stanford to Mr. Robb and copying you. And what is she telling Mr. Robb here?
She's saying, I'm trying to understand why, my AFE for one of the wells includes the P&A cost, the failed drilling cost of the first well, the 2 failed drilling attempts. And then she asked him, if you can please, call me tomorrow, and describe this or explain what's going on, she'd appreciate it.
And turning to Exhibit 7, is it your understanding these are Ms. Stanford's handwritten notes reflecting her call on your behalf with Mr. Robb?
Yes, that's my understanding.
So it appears that she did talk with Mr. Robb. Is that correct?
It is her handwriting, I know that. And yes, she did. It says 318 that she called him, yes.
And then she has some notes here indicating what Mr. Robb told her. Do you see that there?
Yes, I do.
And what did he tell her to do?
Regarding the cost, she referred him to suggest that he call Jim Bruce.
Who is Mewburn's attorney, correct?
I believe so, yes.
Do you know one way or another whether Ms. Stanford called Mr. Bruce?
I don't think she did, but I don't know. I don't think she did, but like I said, I don't know.
Okay. I'm going to just, instead of going back to your testimony here, I'm just going to whip through the rest of these exhibits. This one looks like it got in there twice. This is Exhibit 8. Can you please describe to the commissioners what this letter is?
Exhibit 8 is a letter dated April 15th, 2020, from myself to Ken Waits of Mewburn, including the executed AFEs and explaining the basis for the amount I submitted to participate in the 1510 2H well.
And did you explain to them why you were submitting the amount that you were submitting, correct?
Yes, that's correct.
And just summarize your explanation that's here in the letter.
I submitted the amount of cost attributed to my interest without including the cost for the 2 failed attempts on the junked and failed 1015 2H wells.
So you submitted the costs that were reflected in the AFE that was submitted to the division in case number 20809. Is that right?
That is correct. Yes.
Turning to Exhibit 9, can you please, oh, and here is the AFE. Is this the AFE that you signed that was submitted to the division in case number 20809?
I believe so. 9.3 or 9.4 million, and I signed it. Yes, that's the amount that we submitted based on that AFE. That was submitted to the division and commission. Yes.
And there were two wells, right? There was the 1510 2H, which is that issue here, and the 1510 1H. Is that right?
Yes, that's right.
And the AFE for the 1015 1H was, you had no objections to that one. Is that right?
That's correct.
And you submitted the payment, and Mewburn deemed you consenting, electing to participate in that well. Is that correct?
Yes, that's correct.
But they rejected your payment for the 1510 2H because you didn't include your proportionate share of the extra 3.1 million. Is that correct?
Yes, that is correct.
Turning to Exhibit 9, can you briefly describe this letter to the commission?
Exhibit number 9 is a letter. There was a response from the letter that we had written to Ken Waits. Bruce Insulaco wrote that letter to us, dated May 15th.
And I'm going to interrupt you here for a second because I think I put these a couple of exhibits in the wrong order. So I'm going to forward to Exhibit 10 because I believe this is an earlier letter. And
I believe
so
that's
let's
correct.
start here.
It wasn't May 15th. I believe you're right. There's a prior letter.
Yeah, so here, this is Exhibit 10. Let's start with this letter. Describe this letter to the commission.
And that's Exhibit 10.
Yes. The April 23rd letter, 2020.
It's a letter. It's a letter from Bruce Insulaco in response to our letter, and it's basically a rejection of our payment and of the payment of the inflated AFE that has the additional failed well cost on it.
Okay, and then he gave you another opportunity to come up with all of the money. Is that right?
Yes.
And then in Exhibit, I'm sorry.
Mr. Insulaco, in his letter, he stated that the only election available to pooled working interest owners is to elect to render payment for the cost of all 3 attempts to drill the first Bone Spring well, including the 2 failed attempts to drill the 1015 2H.
And just to clarify, we don't have the order in front of us right now. We'll take a look at that later. But there is no provision in the order that allows them to charge those or impute those costs on the 1510 2H, is there?
No, there is not.
So turning back to Exhibit 9, and I think this will be done here. Is this another follow-up letter from Mr. Insulaco?
Yes, it is.
And can you summarize what he says in this letter?
And this is exhibit number 9.
Yes, it is. And you should see it on the screen. If I need to make it bigger, I can make it bigger.
I believe from recollection, he's just basically saying that we made payment on one well, it was accepted, but on the second well, it's not going to be accepted. The AFE they rendered to us does include the failed 2 attempts, and they weren't going to accept anything less. So they were deeming us non-consent if we don't make the full payment. and the full payment to them was including the prior to junked failed drilling attempts to drill that prior well 9 months prior or so.
And I'm just going to go back to the last page of your direct testimony to confirm that this concludes your testimony at this time. Is that right?
Yes, it does. However, as applicant, I reserve the right to present additional direct testimony at hearing on this matter.
Thank you. Madam Chair, with that, I'll pass the witness. I may have some redirect or rebuttal later on. So he will be available later for that. And I'll stop sharing unless someone wants me to continue to share.
Mr. Bruce, do you have questions for the witness?
Yes, Madam Chair. Mr. Ragsdale, if the first initial attempt to drill this well had been successful, although they had drilling problems and they had incurred $3 million extra cost, and you had elected to join in that well, would you be liable for those extra costs?
Yes, had I elected to join in the well, yes, I would. I believe I would.
Okay. And I guess the same thing would pertain if they junked the one hole and they moved the rig slightly and they tried again. If that second well had been successful, the answer would be the same, isn't it?
Probably so.
And in these wells, the one you're concerned about is the 1510 B1, the first Bone Spring well. Is that correct?
Yes, that's correct.
And the other well that was drilled was the 1510 B3, which is a third Bone Spring well, in which you also owned an interest, correct?
Yes. Can I pause for a second?
Sure.
I don't see you up on the screen at all, Jim.
I'm just on the phone, Sir Ragsdale. So
Oh,
I'm not
okay. That's
for video, so sorry about that.
Okay. I'm looking for you and I don't see you.
Well, I'm nearing an age where I may soon become a ghost, so just pretend I'm a ghost in the machine here.
Okay.
Anyway, but you own an interest in both wells, the B1 and the B3.
I own an interest in the unit out there. That's correct.
Okay. Do you still own an interest in the production from the B3 well?
Objection form.
Sorry, what did you say after that objection? Something?
Form.
What's your
I'm
concern?
happy. The concern is that he's using different terms for the wells. He's using the B3 term where it's not real
Okay,
clear that what we're talking about here is the 1510 2H, which is, 1510 1H, which is a B3 well. And then, of course, there's the 1510 2H, which is a B1 well. I just like to clarify that we're talking about the 1510 wells here and not the 1510 and not the 1015. It's tongue twister.
Mr. Bruce, would you be able to refer to the wells in those terminologies?
Yes.
Okay.
And
Can
once
you
again, I'm
reform
talking
your
about
questions?
Yes.
Thank you.
The 1510 1H is the third Bone Spring well, correct, Mr. Ragsdale?
I believe so.
And you were given a chance to elect to join in that well.
Yes.
You did not timely elect for that well, did you?
I don't know the dates. I think we were told we did, but I don't know those exact dates.
Assuming you didn't timely elect, and I'll have testimony on that from my own witness, Mewburn still let you into that well after that failure to elect, did they not?
Yes.
Okay. And do you still own your interest in production in that well?
I own an interest in that well.
4.89%.
I don't know the interest offhand.
Well, your testimony at page 2, at the top of page 2 of your testimony, it says you own 4.89% working interest in the spacing units and wells at issue in this proceeding.
Yes, it does.
Is that 4.89% correct for the 1510 1H well?
That was the correct amount that I owned and that we paid on, yes.
Do you own it now?
Like I said, I own an interest in that well now, yes.
How much?
I don't know the amount offhand.
Okay. Did you sold that interest to a third party?
That's right, and I retained some interest.
Okay. Did you also try to sell your interest in the 1510 2H well, the first Bone Spring well?
Yes.
That didn't materialize, did it?
No.
Now, you're challenging the extra $3 million plus or minus in well costs for the 1510 2H well. When was the first time you submitted a challenge to Mewburn Oil Company regarding those costs?
I believe the first challenge would have been when Karen Stanford called Mitch Robb to ask him about this inflated AFE, and that extra $3 million, as you say, was slapped on that AFE for another well.
I'll have Mr. Robb testify about that phone call, but isn't it your April 15
Mr. Bruce, can I just ask you to keep the commentary to a minimum? You're welcome to put your witnesses on and testify about whatever they need to, but if you could at least limit the commentary during your questioning, please.
Okay.
Thank you.
Just a couple more questions, Madam Chair. When did you become aware that the original two attempts to drill the first Bone Spring well were unsuccessful?
I believe sometime, months after those two failed attempts occurred in a phone conversation.
Phone conversation with who?
I don't recall. There were a number of people that would call us with questions and ask us. I don't recall who it was.
And you did Did you receive information on those wells from Tracy Anderson, from whom you acquired an interest?
I did not receive any information from Tracy.
Now, just one final thing. The election letter was sent to you by Mewburn in what, early March? Is that correct?
I believe that's correct.
Letter from Mitch Robb to you, your exhibit 5. Is that correct?
Yes, I believe that's correct.
Were you in your office during the month of March?
For most of the month we were in the office, yes. Thanks.
That's all I have, Madam Chair.
Thank you. Commissioners, do you have questions for Mr. Ragsdale?
Yes, I do, but I don't know if I can go fast. Okay.
Go ahead.
Okay. Mr. Ragsdale, I do have a couple of questions for you. Mr. Bruce made mention of Tracy Anderson. I didn't see her name in any of your testimony. So I want to know who she is, and then did she has anything to do with the well that failed?
The last part of your question, does she have anything to do with the well that what? That
The well
failed?
that failed. Yeah. Did she had any consensus? Let's say, did she had any agreement with Melbourne before you took? Let's say, yeah. Did she had any interaction with them? Because I had Bruce asking about her and her notifying you about the failed well attempt.
No, that's not true at all. Let me answer that question, and I'll explain everything. Tracy Anderson's a dear friend from Midland for probably 30, 35 years. And Tracy had a number of interests with us, and she went through a divorce, and she wanted to go ahead and, she didn't want those interests anymore that were with our company that we operated. So we bought her out of the interest with us. And then as she got deeper in the Mewburn stuff, she wasn't happy. She was spending a lot of money. It wasn't making any money for her. And so she asked me if I would just take over her interest for her. Now, those two wells that were junked in the month of July of 2019. And I didn't even acquire Tracy Anderson's interests. It was in a number of Mewburn wells, primarily the Gazelle wells and the Ibex wells, the early wells that Mewburn drilled that were 1 mile laterals. Nothing to do with any of these wells and these orders or what's that matter here. Tracy wanted to unload them. It was costing her money. She, like I'd mentioned, was going through a divorce, so she didn't want anything to do with Mewburn, didn't want those wells. She asked me if I would just take her interest from her. She wanted just to give them to me. So there was no mention of any failed wells. She was just very unhappy with all the money she was spending and wanted to get out of it.
Thank you. I do have another question. So on page 3 of your testimony, so you were asked about when you did not object to the appearance. So I'll read that. You say that I'll just the last part of it to just answer to pose my question. Seeking to force pull the same lands, but for the purpose of drilling the 10 wells. So don't you believe that those force pulling that Melbourne applied for in that same land was specifically to drill the substitute well?
Yes, in a way. They were wells that were going to be drilled, and they had an order. The prior wells, they did not have an order. We were not force pooled. Mewburn elected to drill those wells without a force pooled, without an order. I didn't know about those wells. I didn't have any reports on those wells. I didn't know those wells were happening. I had no idea until somebody, as I mentioned prior, called me months later asking about these failed drills. We didn't get reports. We had no knowledge of them. But on what your question you're asking is, yes, they're similar wells, but there was no indication that there was going to be those failed costs of $3 million placed on me 9 months later in which Mewburn did not have an order for.
Mr. Bruce asked you that if those wells were successful, would you have consented to it? And you said yes in the cross-examination, right? So then why, if it failed, you don't want to consent?
We never had the opportunity. We were never force pulled. They did not have an order.
So let me ask this one more. Let me ask this. Mr. Bruce talked about the other interest owners in the cross-examination that did, in his opening statement, that they did not object to any of these, so they consented to it. Why is this so different from you?
It's different in the sense that we would have made a presence. We would have appeared if we knew they were going to try to slap some, the two failed wells cost of $3 million and on us 9 months later that we had no knowledge of, we didn't know about. They didn't reach out to us. They didn't communicate with us. Again, they weren't even sending us daily drilling reports. We had no idea what's going on.
So back to the AFE question, and as an industry expert, definitely that the AFE is not a static document. It is dynamic, right? It changes. So you talked about Melbourne did not notify the division, or let's say give them the correct AFE, right? So do you believe that just the AFE omission, or let's say the correct AFE provided to the division, violates, or let's say nullifies the order that the commission or the division gave?
Yes, I do. I believe it violates it because why didn't they present that AFE with the extra $3 million? Why didn't they present that to the division and commission? I think that was the right thing to do and the fair thing to do. Then everybody would have known about it. That's what I call disclosure and accountability. Yes, to answer your question, I believe that's not the same AFE. It was for like 9.3 or 9.4 million, and the one they gave me is for what, 12.5 million. I think that's wrong. That's not right.
So do they reserve the right to also provide the updated AFE after the successful well is drilled to the division?
No, an AFE is an estimated well cost. It's before something happens. They were taking some actual costs from the past 9 months prior, correct? That AFE they sent me, the inflated ones, dated March, I believe. And the two junk wells were in July of 19. So 9 months prior, they had some actual cost that they're taking and just trying to slap it on an AFE. And I think it was kind of deceivingly. They didn't give you all the same AFE. They just mailed us one and said, pay this amount or we're going to non-consent you. And we had questions, and that was the questions that Karen Stanford was trying to ask them about. Hey, what are these costs, these additional costs on these AFEs? That it doesn't seem right,
Yeah, my last question to you is, as you go through the testimony and the exhibits that you've shown to us, it sounds to me that Melbourne tried, to more or less reach a consensus with you, but I guess you didn't want to collaborate.
That you're saying that we didn't want to collaborate?
Yes, because if you look at all the testimony, you can see how they are moving. They are trying to get you on the table. Because if you look at your evidence and based on your lawyer statement, I think the question was asked to you that when Mr. Robb and Ms. Stanford, when they had the initial conversation, the Stanford was supposed to call Mr. Bruce, and you said probably she did not, right? So they gave you the opportunity multiple times, to come to the table, to come to a consensus. But it sounds to me that it all didn't work out.
You
Dr.
know,
Ampoma, sorry, let me interrupt really quick. Can you make sure to frame this as a question, please, if you're asking Mr. Ragsdale a question?
Okay, sure.
Thank you.
So then the question is, it sounds to me that you did not want to collaborate, you
That,
did not want to collaborate.
let me answer. I don't think that's true at all. I mean, I appreciate your question and you bring up a good point. We tried to collaborate. As a matter of fact, we sent in the money. We sent in the money for both of the wells. And on one of the wells, they had the inflated cost. It's not that we argued or whatever. We asked about those costs. And I'd have to ask, here's my answer to you. Jim Bruce is not an employee of Mewburn. I mean, who concocted this idea? Who came up with this scheme? She asked the representative of Mewburn, why are these costs on here? And his reply was, call our outside attorney. He'll tell you or something or whatever. And she's wondering to herself, what am I doing calling an outside attorney? I don't think Mewburn would ever contact Ms. Shaheen, our attorney, our attorney. Mewburn is the company. Mewburn's who presented that AFE to the division and did not include those inflated costs. She was asking them. It's their company. It's their people. And she was asking the representative of Mewburn, and he obviously didn't want to answer. He hid the question. He didn't want to talk about it with her. He said, call Mr. Bruce. And I think we did not, it's not that we didn't want to interact with them. We even sent our check. We paid, and they rejected it. And that's what this whole matter's about. You're correct. The whole matter's about them taking the two failed wells of approximately $3.1 million and then placing it on us that we're forced pulled owners. And they did not have a CP. They went ahead of themselves. For whatever reason, they decided they would take that sole risk of drilling those wells without getting an order from the division. And then they went behind and submitted lower AFEs than what they intended to submit to all of us forced pooled owners.
Madam Chair, thanks so much. I have no further questions.
Commissioner Bloom, do you have questions?
Yes. Thank you, Madam Chair. I don't know if this is for Mr. Ragsdale or Ms. Shaheen. Do you have in your evidence here the contrasting AFEs, ones with lower prices that apparently were sent to the division?
Yes, they are in the exhibits.
Can you pull those up for me, please?
Yes, I'm assuming you want to see the AFE for the 1510 2H that was submitted to the division. Is that right?
Yes.
Okay,
Thanks.
okay. It'll take me just a second to remember what the PDF page numbers are. Okay, I am going to share my screen now. And I believe this will be the one that was submitted to the division. And make it a little bigger that you won't be able to see the whole thing. Oh, here we go.
Oh, there it goes. Okay.
Sorry.
Yep, it's up.
So this, I'll scroll down so that you can see the cost and the date. And I believe this is part of the Exhibit 5, which are the exhibits that Mewburn submitted to the division.
Thank you. And that's Exhibit 5, and it looks about 9.3 million. And what was the date on that? I can't quite read it. Looks like 9/12/29.
That's right, September 12th. I'll make it a little bigger. September 10th, 2019. And I'll just scroll up to the top to confirm this is the 2H. Yes. So you can see here that it's the 1510 2H.
Okay. Thank you. No further questions at this time. Thank you.
I just have, I think, a couple questions. So, Mr. Ragsdale, did I hear it correctly that you are saying you were not notified for the pooling of the 1015 wells?
Not notified. We may have been, whenever we were notified, it was well after they drilled the two, they'd made the two, not one, but two failed drilling attempts in July of 19. We were notified of a hearing maybe weeks or months later, or when the order came out.
So you're saying it looks like what the initial well proposals for the 1015 wells were mailed out on March 19th of 2019, and it indicates you received them on the 21st. So you're saying you never received those?
No, we received those. I'm sorry. I thought you were talking about an order.
And then, okay, so you received that, and then let's see. Did you receive the notice to pool on June, in case number 20580 on June 6th?
On June 6th.
Of 2019?
I'd have to see that document. I don't know that date offhand.
Maybe general, did you receive the notice to pool in application for case number 20580?
I believe we would have received a notice, yes.
And then you did not make an appearance in that, correct?
Correct.
So your contention is that you never received the final order, not that you were not aware of the wells? Is that correct?
We were not, that's basically correct. We were not aware of the wells. They didn't send us daily reports. We had no idea they were drilling the wells. We had no idea they'd failed on the two wells and spent all that money. They didn't send us any daily reports. And
Is
so
that
as
a requirement?
You know, Ms. Sandoval, I don't know the requirements, but the way Mewburn does things their own way, and if you own an interest and you're going to be forced pooled, they generally will keep you off the reports. They refuse to send you any reports or share information until you've paid your money, you know, after the forced pooling order and after they've invoiced you. They can be drilling wells and you're going to participate and you've paid, and they're not going to send you reports until either you ask for them or they've received your money. They do not send reports. We generally have to ask them, request them, and sometimes numerous times, and they finally put us on the reports to receive the data reports to know what's going on out there. So we had no idea of the 1015 wells. We did not know.
So if that was your understanding on how Mewburn operates, why did you not enter an appearance in that original case 20580 when you had gotten notice about the forced pooling? What I'm asking, do you understand what I'm asking?
Not really.
What you just stated to me sounds like you have concerns with Mewburn's operating practices and reporting, et cetera, through the drilling process. Is that correct?
Yes, that's correct.
Okay. So if you have concerns about how Mewburn operates and the type of reporting that they provide during the drilling process, why did you not participate up front in the forced pooling application and say that you had an issue with being forced pooled?
Well, we generally don't have an issue. What's at issue are the difficult JOAs that they present us. The JOAs are not acceptable. So thus we don't sign them, and thus we get force pooled. But to kind of answer, so we signed a JOA with Mewburn back in 2016, and we've never signed one with them since. And we've probably been in 25 wells with them. And so, but to attend a hearing, then it would probably, first off, it would have been Ms. Stanford's recommendation. She would have had a cooperation with Ms. Shaheen, and they would have told me they thought it's a good idea. We generally try to work with Mewburn. We call them, we ask them, and try to get things done. A lot of times they don't do stuff. I have to call Ken Waits, the president, who I've known for about 30 years, and then he makes it happen for us in the past. So we try to work, we try to exhaust, we try to work hard with them to get the things that we need or things we like to have. But back to your question, I don't know what's required on the reports. That's a good question. And maybe in the future, do we have to, I guess we need to come to Santa Fe to a hearing then to just to get our drilling reports or to have Mewburn correct them from now on. That, I mean, as I stated to you, they refuse to send reports until what they've told us is, they can be drilling a well and you're in the well and you're force pulled and you're going to pay them until they receive your monies. Then they put you on the reports, and the well could have already been finished, by the time you've paid, and you didn't know what happened and you couldn't monitor the daily progress nor monitor the costs.
I guess I'm just confused about the contention. You're still contending you didn't know about the wells, yet you were notified about the applications, correct?
Correct. We didn't know the wells were being drilled at the time. We just received some paperwork from them. Maybe, as you mentioned, the notice to drill, but we didn't know they were being drilled. They happened without our knowledge. And we didn't find out. There was no polling the partners. There was no asking the partners. They encountered a lot of drilling difficulties. I mean, this wasn't just a couple $100,000. They'd gotten down to a couple thousand feet on each well. They encountered a lot of difficulties, and they elected to dry drill, which is a very, dangerous drilling practice, and they ended up losing both wells. They didn't poll the partners. They didn't talk to anybody. They just did everything, at their own sole risk when they didn't have an order. They didn't ask us anything or mention anything.
Is it common practice for operators to poll the partners on how they are going to drill the wells if Mewburn is the one who is operating and drilling the wells? Is that common practice?
When Mewburn's operating, that's not common practice. They don't reach out to anybody. They don't share information. They don't poll partners. They do everything their way. When most other operators, when they run into problems, they'll notify the partners. And then every once in a while, they'll send out election ballots. Do y'all want to, we'll give you an election right here. Do you want to do this? Do you want to do that? We're at a difficult point right here. We're at a decision point. Do you guys want to have some say-so in what we decide to do next? With Mewburn, that's not the case.
And how is this prior knowledge that this is how Mewburn operates?
Yes, we have probably other 30 or 40 other operators that we deal with. So most reach out, and most want a good relationship with all their working interest owners.
So if you had a concern about being force pooled by Mewburn ahead of time because their standard operating practices and you don't prefer them, why would you not make an appearance during the pooling application or any point during the process?
I mean, we don't have a problem with we don't ever have a problem with the pooling process because we get force pulled because we're not going to sign the JOA. It's too It's too egregious. It's too difficult of a JOA. But it's never been brought up that we need to go to a hearing, a force pulled hearing, to go and discuss like receiving drilling reports or getting better communication from Mewburn during the drilling and completion process. But that's a good point you bring up, though.
But aren't you contending that two pieces, one, that the orders should be revoked because there was not proper notice, or that there should be relief on the costs, correct?
That's correct. I mean, we always thought it was black and white. You have to have an order before you drill. Otherwise, you do so at your own risk and own peril. And they did not have an order before they drilled. It's very clear right here. And you know, when they have the orders, you know, we're forced to prepay up front. And so that was one of the, you're right, that's one component of it. And then the second component is they took that $3.1 million and they're kind of masking it on another AFE. And I say masking it, you know, that was not the AFE that was presented to you all, to the division or the commission. It's a different AFE they presented to you all. And I think accountability and being clear and being, you know, if they wanted to present a higher one, I don't know if y'all would have agreed to that or said to that, but they did not do that. They presented a lower AFE, the actual well cost, whereas in my case, they took that, they're taking, I mean, what they presented to you all is going to be an estimated well cost for one well. What they're presenting to me is going to be an estimated well cost plus actual well cost for the 2 failed attempts.
For the 1510 wells, were you notified for those pooling applications?
I believe so, yes.
Did you participate in that compulsory pooling hearing?
No, we did not.
And that was where the original AFE of the $9 million something was presented, correct?
That's correct. The 9.3, you're right. That's the original that was presented to y'all. That's correct.
And maybe this is Ms. Shaheen, what was the date of the second AFE again? The first one was, I think, 9/12 of 19. What was the second date of the AFE that you received?
I believe it. I'm sorry, Mr. Ragsdale. It sounds like he has the answer.
No, she asked you, but I'm sorry.
I believe it was in March of 2020 when he received the election letter for the 1510 wells.
Is it have you seen before where an AFE differs from what was presented to the division as opposed to what's presented to you later with actual costs? Mr. Ragsdale?
Oh, no, I've never seen that before. That's the first time ever in our history of seeing that.
So of all the wells you've participated in, all of the AFE costs are down to the dollar the same as the original AFE that was presented to the division, which is usually an estimate?
Yes, it's the estimate, you know, of one well. I've never seen multiple well attempts or some past actual cost being placed on an AFE, you know, for another well. Never seen that before.
So you've never had a failed well attempt in your history?
We have had failed well attempts, but we've had the force pooling order where we paid. They had an order beforehand. Yes, and you paid.
Have you done any research of either surrounding wells or similar situations to this where initial drilling failed and what the costs were that were passed on to operate or some of the participants in those wells? Like, have you done a sampling of either surrounding or situations that are similar to this and what occurred with the costs in those situations?
You know, we've had just numerous discussions, and most of the discussions, they lead to, it's back to the order. When you have an order, then you can go ahead and proceed and drill. If you don't have an order, you're drilling at your own peril and own risk. That's what
Right.
most people will say in the business, in the industry, is that that happens. Yes, to answer your question,
Right.
that's what the people we talked to. That was the conclusion.
I don't think that answered my question. My question was, are there situations where a well has failed on drilling in the surrounding area, or similar wells, and that cost was then passed on later? Did you do any research into other similar situations and how that was managed?
Not in a similar area, like in this little immediate area of New Mexico. We didn't do any like study on that. But yeah, there are mechanical failures happen and drilling failures do happen. And like I noted earlier, a lot of times then the operator reaches out to the partners when you reach a decision point. You know, who wants to proceed? We've lost circulation. We're not able to regain circulation, but we're going to try to. And they give you an election at certain points. You know, do you want to proceed ahead, or or do you want to go ahead and opt out of this one?
But
So
that's
you're
not,
given.
sorry, go ahead.
No, I'm sorry.
But that's not required, correct?
I believe you're correct. I mean, it's not required. I think if it were required, it'd be by either a JOA or it'd be required by the division or commission.
Okay. I don't have any further questions at this time. Ms. Shaheen, do you have any redirect?
I'd like to make an effort to clear up the questions about notice. And I don't think it'll take me too long, if you don't mind.
Madam
Go
Chair,
ahead.
can I ask just a couple more questions, please? Either before or after redirect? I don't mind.
Yeah, go ahead, and Ms. Shaheen, you can do redirect at the end.
Okay. Thank you, Madam Chair. Let me put my notes here real quick. Mr. Ragsdale, this is a question I'll have for Mr. Bruce and his witness later, but I wanted to give you a chance just to speculate on this. So there was order 20580 and this failed well was drilled. And if substitute wells are allowed, why include them in a subsequent forced pool?
That's a good question. That's a very good question. And you're asking me just to elaborate or speculate on it?
Yes, thank you.
We operate a lot of properties, and I think I want to clarify, it's not the law, I don't think, but if we had drilled a well without an order, we're at our own risk and own peril, and we would have to absorb those costs. And if we went to the division or the commission for a second order, there wouldn't be any inflating costs, and there wouldn't be trying to go, grab some cost or pull some costs from the past, in which was our error, and our error being not having an order. And so it would simplify the process. Evidently here, Mewburn does not want to absorb those costs, despite the fact that they did not have an order. I think the division would be happy with that. The commission would be happy with that, is what I believe. But that's what I think most operators would have done. It was a mistake they made, and they're not owning up to it. I think that's what's just at heart right here. I think that kind of speculates on your, I'm trying to give you a little my color on your good question there. But we would have probably just absorbed the costs because we made a mistake.
Thank you, Mr. Ragsdale. And I probably should have started with a question I wrote down later, which is it common industry practice to take failed well costs and insert them in a subsequent forced pool?
No, I don't believe so at all. That's not common practice. Matter of fact, this is the first time I've ever seen it happen in all my years of experience.
Yeah, Yeah, thank you. And then one last question, I believe. Just to clarify, both AFEs, the $9 million one from September of 19 and the subsequent one, these are just both estimates before drilling, correct?
Yes and no. The first one is an estimate because it's just about the one well. The second one's not an estimate because it has actual costs from 2 prior attempts 9 months prior. The AFE was done in March and the 2 failed attempts were in July of 19. So one of them, the second one is not estimated costs. It's a combination of estimated and actual costs. I want to clarify that, if I could, please.
Thank you. Yes, right. Estimated plus the cost of the 2 failed wells.
Actual.
Yes, thank you. Okay, no further questions. Thank you. Thank you, Madam Chair.
Thanks. I just, sorry, I have one more follow-up. So you, in response to Commissioner Bloom's question, I think his first question, you said something along the lines of, if they don't have an order, you would have just eaten the costs because that's the right thing to do, correct?
As an operator, yes. If I took the sole risk of our company did, yes.
That's, I think it sounds like that would be best practice, correct?
That's very well said. Yes, I believe that's what I believe. If it was an Exxon, XTO, or a Chevron, they would have known the rules and they knew they violated the rules and they wouldn't have made a fuss about this and tried to slap some cost.
Well, I'd object. See, that's pure speculation. I object.
To his response, I think he can, Mr. Moiner, I think he can speculate in his response.
Yeah, I think that objection, it's not to the questions, it's to the response, and then the commission can weigh that in terms of how they view the statement made by the witness.
Mr. Bruce, I still have a follow-up question. Can I ask my follow-up question and then let me know if you still have a
Sure.
issue? Okay, so while that may, in your mind, Mr. Ragsdale, be best practice, is that rooted in law or regulation?
I don't believe so, to answer your question. That's another good question. And it may be addressed in a JOA, but again, we're force pulled.
Okay.
So, but I don't believe, to answer your question, I don't believe it's rooted in law, and law would probably refer back to a JOA, a contract.
And then I think you said, Mr. Bruce, do you still have an objection that we need to address?
No further objection.
Okay.
I'll just ask my own witnesses.
Thank you. And then I think you responded, Mr. Ragsdale, to Commissioner Bloom's question regarding, have you seen before if prior costs from failed wells have been added into a secondary compulsory pooling application? And you said from your knowledge, they hadn't, correct?
Yes, ma'am, that's correct. From my knowledge, I've never seen it before. And generally, an AFE is just a proposal for one well that has not been drilled, and it's an estimated cost, of when the well will, for the future when the well is drilled. So I've never seen actual cost in the past placed on an AFE, and for other wells as well.
Did you or Ms. Shaheen do any broad research to see if that's, if there have been other cases where this has happened in the past?
I had just talked to a number of people in the industry, and they gave the same answer. The division, they think, not the law, but the division, you have an order. And if you drill prior to the order, it's your own peril, your own risk. but I can't speak for the research that Ms. Shaheen did. I'm not sure of that at this time.
Ms. Shaheen, did you do any research to see if there are other instances where failed drilling attempts have been incorporated in a later compulsory pooling application or down the road?
I have not, but my understanding, and I was going to clarify this with Mr. Ragsdale, is it's a fundamental principle and it's an industry practice that if you do not have an order, which by the way is a law, right? You're required to comply with an order. And if you don't have an order, then you can't do certain things. You cannot impose the cost of drilling, of failed attempts to drill a well on persons who have not had an opportunity to elect to participate under an order. It's a fundamental principle and industry practice. And that's what I believe Mr. Ragsdale is trying to explain. If Mr. Bruce has some case or some, research that he's done that says you can do that, because I've never seen it. And I think what Mr. Ragsdale has just testified to is in his 35 years of experience, he's never seen it.
I would like to respond to that, Madam Chair.
I think, Mr. Bruce, unless you have an objection, I think you're going to have a response to call your own witnesses in a little while.
Okay, but at that point, I'd like to mention a couple of things, and they're in the division's order in this matter, that show that there is law allowing recovery of costs.
Okay, you will get your opportunity. The opportunity is not yet, though.
Thank you.
Okay, thank you, Ms. Shaheen. I don't have any further questions. So if you'd like to redirect.
Thank you.
I do have another follow-up.
I'm
Yeah, I do
sorry, Dr. Impoma.
Yeah. Okay. So, Mr. Ransdale, I do have a follow-up question. So, like what we are discussing here now, I want to know, even if you can add your failed attempt to a substitute well, if you violate an order, let's say you drill the well prior to issuing of the order, does that still equate the fact that you can still add that cost?
I don't believe you can add those costs. I don't believe you can if you drill it, as you stated, before you have an order.
Why did you not? So in what condition would you have made an appearance? Because you've seen all of this. So in what condition would you have made an appearance to when these applications were brought to, let's say, the division to drill the substitute well?
If we had known that they were going to try to place those two failed costs, the $3.1 million, on us as force pulled owners, then we would have definitely have made an appearance at the hearing.
Thank you, Madam Chair. No further questions.
All right, now, Ms. Shaheen, I think you can redirect.
Thank you. I think actually Dr. Impona might have clarified the issue that I was going to address, but I'll take a quick run at it. Mr. Ragsdale, you don't have a concern about being force pooled, is that right?
No, we do not at all, no.
And you don't dispute that you had notice of the applications, is that right?
That's right, yes.
The issue is you did not have notice of their intent to impose the cost of the junked wells on the 1510 2H, correct?
Yes, that's correct.
And as you just explained to Dr. Impona, if you had known that that's what they intended to do, you would have entered an appearance, correct?
Absolutely, we would have been there.
But that information wasn't in the application, right?
That's right. That's
and
correct.
It wasn't in the notice letter, was it?
No, it was not.
And if you had entered an appearance, you would have received the pre-hearing statement, right?
That's right, yes.
Did Mewburn inform the division in the pre-hearing statement that it intended to impose those costs on the junked wells on the 1510 2H?
No, they did not.
And you and I have both reviewed the exhibits and the transcript from that previous hearing. Did Mewburn inform the division at the hearing that it intended to impose the cost of the junked wells on the 1510-2H?
No, they did not. No.
So even if you had entered an appearance, you wouldn't have known that Mewburn intended to impose those costs, right?
That's correct. That's right. Yes.
And Dr. Ampona also asked you about substitute wells, correct?
Yes.
And if you don't mind, Madam Chair, I'd like to share one document because I would like to look at the reg for substitute wells. And I need to move some things around here. Okay. Let's see if I can share this now. Sorry, it's taking me a minute here. Let's try this. Does everyone see that?
Yes.
Okay, so this is 19.15.13.8 in MAC that I copied and pasted from the official website for the regs. And if you turn to subsection B4, I've highlighted the language that pertains to a substitute well. Mr. Ragsdale, could you just read that into the record, the highlighted language?
Substitute well is located within 330 feet of the original well, and the operator commences drilling within 10 days of the original well's abandonment.
And so was this well, the 1510-2H, located within 330 feet of the original well?
No, it was not.
And did the operator commence drilling within 10 days of the original well's abandonment?
No, they did not.
So this would not qualify as a substitute well under New Mexico law. Is that correct?
Yes, that's correct. It would not qualify as a substitute well.
Ms. Shaheen, are you going to be putting on another witness to talk about that further?
I am not planning to put on another witness to talk about the law, but I am planning to ask Mewburn's witnesses about the location of the well. And it's not disputed that it was several months down the road actually, I don't believe either of those facts are disputed, although I think there's a spin on it, if you will, when Mewburn's witnesses talk about a so-called mirror well or a so-called replacement well, and I plan to ask them questions about that, but I do not have another witness.
Mr. Bruce, are your witnesses planning to testify about that?
Yes.
Okay. I guess, Mr. Moander, I'm just wondering, this is sort of the first time that we're talking about replacement wells at this point. The commission may have questions for Mr. Ragsdale based on the redirect and the issue that just came up just now. Can we go back and ask Mr. Ragsdale questions about this? Or what's the procedure?
That's appropriate as long as you don't release him after this is concluded. If you want to ask additional questions of him, you should be able to as a party, the primary party in the case. So if you want to reserve questions and examination for further examination of the witness for later on in the hearing, you can certainly do that.
Okay, so we could recall him.
You can recall him so long as as long as you don't release him from testimony,
Okay.
you should be okay.
Okay, I think that would likely be the most appropriate. Okay, I'm just doing a time check. I think we should probably at least take a 5-minute break, but we are at 11:07 at least. Well, almost 11:10. Thinking about sort of timing with lunch, Mr. Bruce, how long do you expect your first witness's testimony to be without questions?
Very brief without questions. I mean, even the questions I ask will be pretty direct, so I don't think my questioning of him would take maybe 10 minutes.
Okay, so why don't we take a 5-minute break now? We'll come back. So we're not excusing Mr. Ragsdale yet. He may be recalled later. So we'll go ahead, we'll do a 5-minute break. We'll start with your witnesses and get through as many questions sort of before noon-ish, and then we can take a break for lunch and come back. Okay, so it's 11:08 right now. Why don't we come back by 11:15?
Thank you, Madam Chair.
Thank you.
Mary, I'm here also.
Awesome. All right, let's get started. Oh dear. Just got a computer restart notification. Perfect timing. But let's go ahead and get started. Mr. Bruce, would you like to call your first witness?
Yes, Madam Chair, I would call Travis Cude, C-U-D-E, as a witness. And I guess I need him sworn in first.
This is Mary. Did you want me to swear him?
Yes, Mr. Cude, can we hear you? I just moved you to a panelist, so you should be able to control your video and audio. You look muted. Mr. Cude. I unmuted you.
Madam Chair, did you unmute them?
I did. He should be able to do everything on his own. Mr. Cude.
Oh, you might have unmuted the. Oh, okay. My next witness, Mitch Robb, he is also on Mitch Robb's computer. So if you could unmute.
I just moved Mr. Robb to a panelist, so Mr. Robb, you should be able to control your audio and visual.
This is Travis Cude. We have one computer set up and Mitch Robb logged in.
Gotcha. Okay.
Okay.
Ms. McFarland, would you mind, well, first, Mr. Robb, would you state your name and spell it, please, for the record?
Mr. Cude is up first.
Oh, gosh. I'm looking at the name under your Mr. Cude. Would
I'm
you
sorry.
please? It's all right. State your name and spell it for the record, please.
Travis Cude, Trabis Cude.
All right. Now, would you swear him in, please?
Mr. Cude, this is Mary McFarland, the court reporter. Would you raise your right hand, please? Do you solemnly swear under penalty of law the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
Thank you.
Mr. Cude, who do you work for and in what capacity?
I am a reservoir engineer for Mewburn Oil Company in Midland, Texas.
And did you have a major part in the drilling of the Ibex wells?
Yes,
Have you previously testified before the division, not the commission?
yes, sir.
And were your credentials as an expert engineer accepted as a matter of record?
They were.
Have you previously testified before the commission?
I have.
And were your credentials as an expert recognized?
They were.
And just how long have you been working for Mewburn Oil Company?
I've been at Mewburn Oil Company for approximately 10 years since I graduated from the University of Oklahoma. And I've been working our Permian asset, being Southeast New Mexico, for approximately 8 years.
Okay, so you are, and are you familiar with the drilling of the wells at issue here today?
I am.
Madam Chair, I'd ask that Mr. Cude be recognized as an expert engineer by the commission.
Commissioners, do you have any questions for Mr. Cude regarding the certification?
No idea.
No, Madam Chair.
Ms. Shaheen, do you have any comments or objections?
No objection.
Okay. Mr. Cude is tendered as an expert in this matter.
Okay. Mr. Cude, did you prepare what I have marked as Exhibit 1, a little self-affirmed statement regarding the basics of the drilling of these wells?
I did.
And do you adopt that testimony today?
I do.
And just briefly, let's look at the timing, which is kind of set out in paragraphs 3, 4, and 5 of your statement. When was the first well commenced? Being the 10-2H, excuse me.
July 7th of 2019.
Did Mewburn, and I can get Mr. Robb to testify more about this, did Mewburn have drilling obligations which required it to commence the well in order to save leases or assignments?
We did, and yeah, Mr. Robb would be better familiar with those pertinent details.
Okay. Now you junked that hole, and what is the basic reason? Loss of circulation that you couldn't do anything with?
Yes, sir, that's correct. After we set 13 3/8 surface casing, we encountered lost circulation below that in kind of an unconsolidated red bed formation, and we stuck our drill string and were unable to fish it out of the hole after multiple attempts. And so, because of that, we decided to junk that hole and start again.
Do you think that was a prudent decision?
Yes, our two recovery attempts were unsuccessful, and there was nothing to make us think that we would be able to get it if we continued trying.
And then the 10-15 2HY well, you just moved that slightly, the surface location slightly, correct?
Yes, I believe it was about 30 feet.
And you had similar results there.
Yes, sir, that is correct.
And so after that, was a determination made to switch the surface hole location from the northeast-northeast of section 10 to the southeast-southeast of section 15 and drill to the north.
Yes, sir, that is correct. We reviewed, what we determined was the shallow drilling hazard, and that surfacing from the south would minimize that risk.
Okay. This is mostly federal land in this well unit?
Yes, sir, I believe it is entirely 100% federal minerals.
And so because of the new surface location, it's one thing to skid a rig over a short distance as opposed to moving a surface location a couple of miles with the BLM, is it not?
That is correct.
And in obtaining a new APD from the BLM for the drill in the subsequent, what we have called the substitute well or replacement well, approximately how many months did it take?
Trying to think here
What-
when we
Well,
filed
let
those
me ask you-
APDs, but it
ask
can
you
it
this.
can take up to from 6 months to a year is pretty standard.
Okay. And, but under the OCD regulation about moving away from a junked hole, getting approval to drill within 10 days was not reasonable. Is that correct?
That is correct.
Okay. Now let's get into this situation about the wellbore itself of the completed 1510 2H well. Do you consider this to be a mirror location of the wells that were spudded up in section 10?
Yes.
Is the same Bone Spring zone was being tested in these two wells, correct?
Yes.
And was the wellbore virtually the same drilling south to north as was proposed drilling north to south?
Yes, I think, in the world of horizontal wells, we typically look at where our first take point is and where our last take point is. And within that, perspective, I believe that the, first take points and last take points of the 1015 2H and 2HY and the 1510 2H are within 150 feet of each other.
So that's well within the 300 feet for having a substitute or replacement well, in your opinion?
In our opinion, yes.
Okay. Now, in drilling a well, an AFE is simply an estimate, is that correct?
Yes.
Problems can be encountered which increase well costs?
Yes.
Let me ask, Mewburn has drilled other wells nearby the well at issue here today, correct?
Yes, sir. I think we probably operate close to 30, if not more, horizontals within this township. Drilled in the bones.
And were there any problems encountered in drilling those wells like you encountered with this particular well?
No, sir, this is the only one.
So it was completely unexpected.
Yes.
And I'll ask you the same question I asked Mr. Ragsdale. When you first encountered problems with the 1015 2H, if you had continued drilling, trying to get through the issue that you had, and had made a well, do you believe, and you'd spent X amount, whatever that may be, 500,000, 1.5 million, whatever, do you believe that cost could have been reasonably recovered as part of the AFE costs?
Yes, absolutely.
And same thing after the second attempt was made.
Yes.
Do you believe that those costs are reasonable well costs?
Yes, sir.
Just a couple of final questions. The costs on the 1510 2H AFE as originally submitted, do you think those were proper?
When you say originally submitted, are you referring to case number 20809?
Yes, sir.
Yes, sir. We viewed those as the costs going forward to successfully drill and complete the 1510 2H.
Okay. Because the other costs have already been incurred, correct?
That's correct.
And was the (1510) 2H well successfully drilled?
It was.
Is it still producing?
Yes, sir. We began producing that well, I believe in December of 2020, and it is still producing.
Has it paid out?
I don't know that it has quite reached payout. I know our accounting system is probably a couple months behind as far as revenue goes, but it would be very close.
Okay, so it should pay out and make a well.
Yes, sir. Absolutely.
And based on that, do you think Mewburn's decision to junk the first two holes and drill from south to north were reasonable?
I do.
And Mewburn acted as a prudent operator?
Yes.
And when you're talking payout, you're talking payout of the total 12 million plus or minus dollars, correct?
Yes, sir. Yeah, 100% payout of the cost.
Do you have anything further to add at this time before I turn you over, Mr. Q?
Yeah, no, sir.
Okay. With that, Madam Chair, I will turn the witness over for cross-examination, and I would move the admission of Mewburn Exhibit 1, which is Mr. Q's self-affirmed statement.
Ms. Shaheen, any objections to admitting Exhibit 1?
No objection.
Commissioners, any objections or questions on Exhibit 1 admission?
No, Madam Chair.
Okay,
No, Madam Chair.
thank you. Exhibit 1, Mewburn's Exhibit 1 is entered to the record.
Thank you.
All right, Ms.
And I have-
Shaheen. Oh,
Yes. No, I was just saying I have no further questions, Madam Chair.
thank you. Ms. Shaheen, would you like to cross the witness?
Yes, thank you. May I share my screen?
Yes, I think you still have permission.
Can everyone see that? I'll make it a little bigger.
Yes.
Mr. Cood, let's just take a look first at paragraph 3. And here you explain when the first attempt was made to drill the 1015 2H, correct?
Yes.
And it was commenced on July 7th, 2019.
Yes.
And at that time, there had been no order force pooling these wells. Is that correct?
I believe that to be correct.
When you had these issues that you discussed, did you talk to any of the working interest owners about the issues that you had run into?
Personally, I did not.
Well, let me ask that in a better way. Did Mewburn reach out to any of its working interest owners and discuss the issues that it was having?
I believe we did. That probably would have fallen under Mr. Rob's purview.
Oh, okay. So I should ask Mr. Rob about that.
Yeah. Ms. Shaheen, I was going to ask Mr. Rob about that, so you'll have your chance.
Okay, thank you. So turning to that fourth paragraph here, you're explaining when the second attempt was made to drill the 1015 2H. And I understand that was in July 26. Is that correct?
When we spud the second well, yes.
And again, there was no order entered at that time, correct?
Correct.
And Mr. Ragsdale had not had an opportunity to elect to participate under a forced pooling order. Is that right?
I'll defer to Mr. Rob, but I believe that would be correct.
Okay. Now, in paragraph 5, you talk about a replacement well. Now, we looked at the regulation earlier that relates to a substitute well. Were you present for that testimony?
Yes.
Okay, and let's just take another look at it while you're here. Let me see if I can find it here. Can you see that?
Yes.
And you see the language highlighted in yellow.
Yes.
And what are the requirements for a substitute well?
Substitute well is located within 330 feet of the original well, and the operator commences drilling within 10 days of the original well's abandonment.
Okay, so you agree that this doesn't, the 1510 2H doesn't fall within the purview of this regulation regarding a substitute well. Do you agree to that?
I believe that our horizontal well is, located within 330 feet of the original well.
Well, we're going to take a look at that in a minute. Did the operator commence drilling within 10 days?
We were not able to do that.
So you would agree that the well, the 1510 2H, does not satisfy the requirements of this particular regulation? Is that correct?
That is correct.
And so you talk about a so-called replacement well in paragraph 5. Do you see that? And that's the first paragraph 5. Oh, wait, let me go back to that. Your first paragraph 5 here, you talk about, and it's right here where my little hand is, replacement well. Do you see that?
Yes.
And is there a regulation that addresses replacement wells?
I suppose there's, I don't know if it's defined as a replacement well.
So, well, let me rephrase that. Are you aware of any regulation that defines a replacement well?
I am not.
Are you aware of any regulation that provides that an operator can impose the costs of a replacement well when a force pooling order was not previously entered?
I'd object because it calls for a legal conclusion.
Well, let me ask it differently. Are you aware of any regulation that pertains to replacement wells?
I believe I testified that potentially, I mean, a substitute well, whether that's an interchangeable term or not.
Are you aware of any regulation that specifically refers to a replacement well?
No.
Turning to your paragraph 5, your second paragraph 5. Here you're referring to what you call a mirror well. Do you see that?
Yes.
And are you aware of any regulation that refers to a mirror well?
I'm not aware.
Let me ask you this. How often has Mewburn drilled a well that resulted in a junked well without a force pooling order?
I don't have that information.
Are you aware of any other time when Mewburn had a failed attempt to drill a well without a force
Yeah.
pooling?
Without a force pooling order?
Right, without a force pooling. Sorry, I'm taking a long time to get my question out.
Not off the top of my head.
So would it be fair to say this is the only instance in which you know of that Mewburn drilled a well that failed prior to getting a force pooling order?
I don't know,
To your knowledge.
to my knowledge.
And just to clarify, to your knowledge, this is the only time when Mewburn has had a failed attempt to drill a well without a force pooling order. Is that right? Is that to your knowledge?
Yeah, to my knowledge, I know Mewburn has been around since 1965 and active in New Mexico, and I've been here since 2014. So to my knowledge, in that time, I haven't been involved in every single well that Mewburn has drilled in that time. But yeah, personally, I'm not aware of that.
Do you know of any other time when Mewburn would have imposed the cost of drilling a failed drilling attempt on something other than a substitute well?
Could you ask that again? I'm sorry.
Yeah, that wasn't a very good question. Are you aware of any instance in which Mewburn has attempted to drill a well and failed without a force pooling order, and then subsequently imposed those costs on a well that does not fall within the requirements for a substitute well under New Mexico regulations?
I mean, I'm sure that there are instances where we have imposed the costs of a failed well that was not subject to a force pooling order onto those parties. Is that what you're asking?
I think so. Again, that wasn't a very good question, but let me see if I can explore it a little further with you. So the circumstance is a little complicated, but in some ways it's pretty simple, right? Mewburn drilled a well. It wasn't successful. They had no force pooling order. And let me ask it this way. Has Mewburn ever assumed the risk and absorbed the cost of a failed drilling attempt?
I'm not sure what you mean by assumed the risk.
Were you present for Mr. Ragsdale's testimony?
I was.
If you did not have a JOA and you drilled a well that was unsuccessful, and you subsequently got a JOA, would you be able to impose those costs on the JOA parties?
I would object. I would object because JOAs are handled by landmen like Mr. Robb and not by the engineers.
Okay, so I should ask that question of Mr. Robb.
Yes, please.
Okay, let me make a note of that. Sorry, I'm still sharing, right? I got to be careful here. Okay, we were talking about whether you talked to, oh, that was another question you deferred to Mr. Robb, sorry. Now you testified earlier about the AFEs. Do you recall that testimony?
For Mr. Bruce?
Yes.
Yes.
And here, let me go back to your affidavit. That might be helpful. This one. Let's try this one. Yes. Okay. And you testified about the AFEs. Are you familiar with the AFEs in this matter?
I am familiar with the AFEs, yes.
Okay. Did you testify in either of the previous hearings?
I did not.
Did you have a
excuse me, let me rephrase that. I did not testify in case 20580 or case 20809. I did previously testify in division case 21324.
Okay, thank you for that clarification. So when with respect to the applications for the 1015 wells and the 1510 wells, you did not testify or provide an affidavit or any evidence in those proceedings. Is that correct?
I did not.
So did, going back to your paragraphs 2 and 3 here, or sorry, 3 and 4, was this information provided to the division in either case number 20580 or 20809?
I would need to look at the timing of case number 20580. I believe that case occurred before these drilling attempts.
Good point. So do you know whether this information was presented to the division in case number 20809?
I did not testify in that case. I'm not aware.
So you're not aware that this information was presented to the division?
I am not aware whether it was or was not. I was not a part of that case.
Is that
But
another question?
I would imagine that this explicit statement is not part of the record.
And why
We
is that?
typically, don't share confidential well information with parties that haven't elected to participate in wells.
So you're saying you don't share this information until after someone has elected to participate?
Mr. Rob could probably, answer this, better and more fully than I can, but that is my understanding.
And that's the reason I'm asking you is because you're the one that has it in your affidavit here, right?
I mean, I testified as to what happened on the drilling rig.
Right. But you don't know whether this information was provided to the division, except for today. Is that right? And the last hearing before the division that Mr. Ragsdale brought.
Yes, yes.
Okay, let's take a look at the AFEs. I brought that up earlier. Got to switch gears here. When Mr. Bloom asked about let's see if this is it. No. Here we go. Okay, here is the AFE for the 1510 2H that was submitted to the division. Do you see that?
I see the top portion there. Yes, I guess if you were to keep scrolling down, let's assume that's correct. Yes.
And it looks like this was prepared by Jacob Maxey. Who's Jacob Maxey?
He works in our operations office in Hobbs, New Mexico.
And it was prepared on September 10th, 2019, correct?
Yes.
And this does not include the cost of the junked wells, correct?
I do not believe so.
And did you participate or assist Mr. Maxey in any way in developing this AFE?
I did not.
Do you know who determined that those costs for the junked wells shouldn't be included in the estimated costs for the 1510 2H?
Can you repeat the question? I'm sorry.
Yes. Do you know at Mewburn who decided that the junked well costs should not be included in the AFE that was submitted to the division?
I do not explicitly know.
When you say explicitly, what does that mean?
I couldn't point to one person. I mean, Jacob Maxey prepared the AFE, but it was approved there by our vice president of operations,
And who is the vice president of operations?
Monty Whetstone.
And that's his signature there where it says company approval?
Yes, ma'am.
Did you look at this AFE before it was submitted to the division?
It's a good question. I would assume I probably did.
Do you know whether at the time this AFE was submitted to the division, Mewburn had already decided that it was going to charge the cost for the junked wells on the 1510 2H?
I'm not certain about that.
Who would know?
I guess we could ask Mr. Rob, probably, our vice president, Bruce Insalaka, who has since retired.
Let's turn now to the revised AFE that was sent to Mr. Ragsdale. So you can see here, this is the 1510 2H. And if you scroll down, you can see the date on this one. Do you see that there?
Yes.
And what is the date on this one?
March 2nd, 2020.
And this was prepared by L. Jackson. Who is L. Jackson?
Levi Jackson is an engineer in our Hobbs, New Mexico operations office.
And do you know whether someone at Mewburn instructed Mr. Jackson to include the estimated cost for the, to include the actual cost for the junked wells in this AFE for estimated costs?
Do I know? Can you?
Yes. Do you know who told Mr. Jackson to include those junked well costs in this AFE?
No.
Do you think that he did that of his own accord?
No.
Have you reviewed this AFE previously?
Yes.
Let's take a look up at the top here. Were you present for the testimony of Mr. Ragsdale when he testified that what he calls inflated costs, the charges for the junked wells, are in this portion of the AFE, the column that's TCP?
Yes.
Do you know who determined to include those costs in this TCP column for the intangible cost?
No. All right. And I guess this is our, standard AFE procedure for sending this out. So it just runs through our operations office.
It's your standard procedure to include the cost for junked wells in the TCP column of intangible cost?
Well, I'm saying, as far as you're asking me who determined to prepare this AFE. I don't, outside of the just kind of standard procedure we have for preparing AFEs, I don't know anything further than that.
Did you review the math that relates to this AFE?
I have not.
Let's take a look at row 4 here, day work, turnkey, footage drilling. Do you see that?
Yes.
30 days drilling. And then there's a rate, $21,500 a day. Do you see that?
Yes.
And so is it correct that you would multiply $21,500 times 30 days to arrive at the amount in this column, TCP?
Potentially, I guess there's also taxes involved, and I think there's a few other things that go into it.
You're saying, have you ever prepared an AFE?
I have.
And do you calculate taxes and include that in the TCP column?
Yes.
So when you multiply 30 times 21,500, you're saying there's additional taxes that would be tacked onto that?
Yes. There's, I believe, sales tax.
So sales tax is what, about 8%? Is that right?
Yes.
That's what you use when you prepare AFEs?
Correct.
Okay, so if you were to calculate 30 times 21500, that results in a number of $645,000. And you can check my math if you want. I used my calculator. So are you telling me that the extra here for the difference between the 1,116,000 and the 645,000 is sales tax?
No, that's not what I'm saying.
Okay. What is the difference between the 645,000 plus tax and the $1,116,000?
I believe it's the the drilling costs incurred on the original wells. The sunk costs that we had already spent included in there.
Oh, so this is where they've been added the costs for the junk wells?
Yes.
Is that explained anywhere here on the AFE?
I'd probably defer to Mitch Robb. We typically don't just send out AFEs to parties. There's usually a proposal letter, which he would have prepared that would probably cover some of your questions on this.
Well, let's take a look at that proposal letter. Or do you think I should wait on Mr. Robb to look at the proposal letter?
I would object to any questioning because that's Mr. Robb's, he testified about that at the prior hearings.
Mr. Robb did? Okay. Hopefully I'm going to remember all these questions for Mr. Robb.
Ms. Shaheen, I just want to do a quick time check. How much longer do you think you have in terms of questioning? And that'll dictate when we take a break. We break now or we wait until you're done?
Well, since it seems like Mr. Cood is deferring many of these questions to Mr. Robb, I'm going to go out on a limb here and speculate that I won't be any more than 10 or 15 minutes with Mr. Cood.
Okay. We'll go ahead and finish your questioning then, and then we'll take a lunch break, and then we can come back for commission questions. Go ahead and continue.
Thank you. Now I want to go back to your previous testimony about the location of the well. And I'm going to turn now to the order that was entered in 20809. I believe Mr. Bruce attached that as attachment C. Have to switch documents here. Try this one.
Maybe B.
Is it B? Let me see. No, I think it's C, and I think it's at PDF page 10. Okay, so here's the order that was entered. Oh, this is the order that was entered in 20580. Am I getting my numbers mixed up? Oh, it's D. You're right. It's D. Sorry about that. Okay, here we go. Case number 20809 R-20924-A. So here we have the order, the findings of fact, and what I want to take a look at is the exhibit here. It's Exhibit A, which describes the wells that are being force pooled. And here we have proposed wells. So this order pooled all 4 wells. It pooled the 1015 1H, the 1015 2H, the 1510 1H, and the 1510 2H. Is that correct? Oh, here, wait. Now, does that help?
Yeah, I guess we pulled the spacing unit, and then the proposed wells here are the ones that you listed. Yes.
Right. So this order was dedicated, this unit is dedicated to these 4 proposed wells. Would you agree?
Yes.
And in your experience, when you have a force pooling order or compulsory pooling order, and there are multiple wells, isn't it true that you send out an AFE for each well?
I mean, I typically don't deal with the notice or the force pooling process. It's usually handled by our landmen.
Okay, that sounds like another question for Mr. Robb. But let's look at the locations of the wells, because I think this pertains directly to your testimony. So here we have the IBEX 1015-2H. You see the surface hole, 375 feet from the north line and 1,107 feet from the east line.
Yes.
And if I understand correctly, these are flipped, right? So that the surface hole would be analogous, the surface hole of the 1015 2H would be analogous to the bottom hole of the 1510 2H. Do I understand that correctly?
No, not particularly. I know that we would have filed directional surveys in our exhibits for these pooling cases, which would have outlined where our first and last take point for each well is. And so I don't know that the surface location is particularly I guess, as you said, a mirror to the bottom hole location. But as far as the first take point and the last take point, of our well, where that well is traversing, yes, those are effectively mirrors of each other.
In your opinion?
In my opinion.
So are the first take points and the last take points provided on this Exhibit A?
I don't know. I don't see them on Exhibit A. But as I mentioned, in the case files for 20580 and 20809, we would have submitted a directional survey, which would show those take points, and taking those into account, I mean, they are within 330 feet of each other.
Let's take a look at that, because I know I have C102s in a couple of different places here. Let me see if I can find the ones we need. Okay, this appears to be the 1015 2H. Can you identify the take points here?
This is our C102. This is not our directional.
Okay, so let me go to the exhibits, see if you can direct me to those directional surveys. So I'm going to go to Exhibit 3. And this is kind of a long, if I put survey in here, would it pop up? Or as I scroll, you tell me if you see it. Here's the C102 again.
Excuse me, just for ease of reference, the directional pulling plans would be right at the end of the geologist's testimony. So
okay, that's helpful. Let's go here. Oh, geologist, okay. There's,
past all of the geologic plats.
okay. Am I getting close?
Yes. Yeah, so there, right there, you have a first take point of 100 feet from north line and 450 feet from east line. And then our bottom hole location there, 100 feet from south line, 450 feet from east line.
It's interesting. So the first take point and the surface location. Okay. And where's the last take point?
Well, generally it's probably pretty close to the bottom hole location. So I don't specifically see last take point on here, but I mean, our bottom hole location there is at 100 feet from south line and 450 feet from east line.
Okay, so the last take point is not reflected here. Is that correct?
It may show up, in more of, I know this is a pretty long document. But
Well, I think this is the end of it.
if you were to keep going there, okay. Yeah, I don't have our exhibits that we filed in this case right in front of me.
Okay, it looks like I might have to do a little homework over lunch to explore this a little further. Let me just take a minute to see if I'm done here. You previously talked about a payout for this well. Do you remember that?
Yes.
When do you expect to reach payout in this well?
I guess that's subject to a lot of factors. But assuming a consistent oil price and operating costs, we model that we would achieve payout. You know, if nothing were to change, I'm sure certainly within the next year.
So that would be a year and a half to 2 years after drilling.
Yeah, certainly after the well came online, December 28th of 2020.
And have you provided the participating parties a payout statement?
I don't deal with that. I'm not sure. I mean, if the well hasn't paid out, I don't know that we would have sent one, but I'm not sure.
Okay, I'm going to stop sharing just for a minute so I can make sure I'm done here. Oh. Okay, I think that covers my questions here unless if I need to follow up with you about the first take points and the last take points, then I would ask that you be available. But if Mr. Rob can testify to that, I'm fine with that too. And I pass the witness.
Thank you. All right, it is 12:12. Why don't we take an hour for lunch and come back at 1:15? We will continue with Mr. Cube when we start back up with commission questions. Mr. Moander, would you mind staying on for a minute while we figure out this computer restart thing, please?
Absolutely, Madam Chair. Happy to help.
All right. Thank you. All right, everybody else, we'll see you back at 1:15.
Thank you.
All right. I think Mr. Kood, you're still up. Ms. Shaheen, it sounded like you might have a follow-up question before we go to the commission.
No, I'm good. Thank you.
Okay, great. Well, commissioners, do you have questions for the witness?
Yes, Madam Chair, I do. So if
Go ahead.
Okay. Mr. Kood, I know you are engineer, so I guess I can ask the technical questions. In number 3 of your testimony, the exhibit, the one that you showed, the well commenced July 7th, 2019. And I want to know, was the order received, in terms of the force pulling, received prior to the drilling this well on July 7, 2019?
Look through my history here. I believe the order was received after that date.
So you're saying the order was received prior to this date or after this date?
After.
So then it means you commenced drilling before receiving the force pulling order.
Yes, sir, that is correct.
In number 5, the first number 5, you talked about after the failed attempt, Melbourne decided to move to a good location, where they feel that it is the best location to drill this well to avoid the same problems that you guys encountered in the 2 failed attempts. Now, my question to you is, and if you cannot, I guess Bruce or any of the witnesses can respond to that. Did you reconcile with the law, or clarified with the division before moving to the new location to still make sure that you guys were, Melbourne was in compliance?
That is it's a good question, and I'm not sure about that. Whether we did consult the division or not.
Now in number 5B, so the second number 5, and we all understand that there could be some delays, especially when dealing with BLM. So definitely there was a little bit of a delay there. But I want to ask, is there any accommodation under the New Mexico state law to account for this potential delays, to avoid that 10-day lapses, for the well to qualify for a substitute?
Yeah, I guess it's my understanding. I think that the administrative code as it relates to that probably hasn't been updated since 2008. Prior to really the modern horizontal development in New Mexico. So I don't believe it does.
So do you believe then the division or the commission needs to look into that?
Yes, sir. Yeah, I think that would be reasonable. I think most, rigs nowadays, we're drilling multiple horizontal wells from a single location. Our rigs have walking packages that are, maybe 150 feet, of lateral movement there. So I don't even know that it's feasible to, be able to spud a new well within, 10 days within 330 feet as that's, stated. And then obviously, yeah, again, with, just the BLM and the backlog that they have as far as permitting goes, I've never seen an APD be issued in 10 days from them, at least, in the last few years. And certainly, I think that you would absolutely have to apply for a new APD if you were to move quarter sections, which even under the division's rules, could still be within 330 feet, and you would need to apply for a new permit there. And so, I think you're right that, or I guess just to answer your question, I do think that this is something that should be looked at.
Okay, now to the engineering questions. You talked about there were potential lapses in the deadline for the lease. So that is why Melbourne moved ahead to drill the well, probably before even receiving the order. Now I want to ask that did Melbourne rush into drilling this well without doing due diligence, to save the deadline, the lease deadline, where they did not really account for potential shallow drilling hazards that really caused the failure of the wells?
I don't think so. I'd have to check my, data on this, but these were the 7th and 8th wells, at least let's call them the 10, 15, 1H and 2H. They were the 7th and 8th wells that Mewburn had drilled in these 2 sections. And so we had a history drilling here, we've done our homework over a number of years here. We just encountered, a hazard that, we, obviously weren't able to work through, and, just by flipping the locations, we were able to solve that. I think it was just, I don't, if you want to call it a sweet spot or the opposite of a sweet spot, whatever that would be, but again, I don't think that we rushed into drilling these by any means.
So do you know, in terms of the substitute law that was shown to us today, do you know if there is a different description with regards to, let's say, on the BLM land, or is it the same with New Mexico? Do you know? For a well to qualify to be a substitute well.
What the federal regulations would state?
From the state, do you know?
I don't know off the top of my head whether they have specific regulations as to what a substitute or replacement well would be.
Now, let me ask, so with regards to, you talked about the horizontal well, probably this rule needs to be amended here and there. So from your opinion, what do you feel in this situation that we're dealing with, qualified as a substitute well?
Yeah, I think that, certainly the division standoff, I think in my opinion, the 330 feet, probably has something specifically to do with the source of supply that you are, drilling to produce from, and that, if you were to move more than 330 feet away from your original location, there's a possibility that the geology could change, and I think that's the premise of the law, and why that's written is that it's probably not the same well, and the produced formation could be different, and so from this standpoint, I do think that our application of first take point and last take point, being within that same 330 feet, mitigates that, it complies with the spirit of the law there as we interpret it. And so, really, I think it's just a matter of, continual operations, diligent operations to spud a replacement well. There are a lot of things that go into, drilling a 2-mile lateral here. And so, as long as, you're diligently getting the appropriate approvals from the regulators, be it the BLM, be it the NMOCD, and that that you work to spud a well within a very reasonable manner, that should be a substitute or replacement well.
In your testimony, you talked about how Mebon will not share well information or even the drilling processes, whatever concerned with that particular well, with parties that have not elected to participate. So why do you guys do that? Why do Mebon do that?
Well, so, obviously, everyone has an opportunity to elect to participate in a well before we spud it. I mean, we send out well proposals. They can voluntarily sign a JOA. And so certainly the parties that are subject to the JOA that have elected to participate in the wells, we share all the well data with them. And they're an owner. They've paid their bills, and so they have a right to the data. I guess in the matter of forced pooling, I think it's pretty industry standard not to share confidential well information with parties that haven't elected to participate in those wells at that point. And I think that's probably the risk that a party takes when they don't consent to join a well under a JOA.
So then does that mean that not electing to sign the JOA, and probably they have not been force pulled, does not still necessarily relieve them of the financial responsibility if they want in the future wants to sign a JOA, or probably they are force pulled.
I'm sorry, I missed your question there.
Okay, so I'm asking, you don't share the confidential information with companies that have not elected, to join. Now I'm asking that if a company decide not to join, okay, and they are not force pulled, or let's say there has not been an order received that has forced them to join, will you say that that does that not still, or let's say, does that relieve them from any future future expenses when in the future they elect to join?
I guess if you're asking as to the particular well,
Yes.
not as to like potentially infill wells drilled in that operation unit. Yeah, I mean, I think it would be our opinion, and I could defer to Mitch Robb on this as well to get his opinion, that if you elected to participate in the well at some point, you would be subject to the costs of that well.
Okay, let's see. Now I want to ask you, so this issue that is before the commission, I want to have your take on that. You've been in the industry for almost like 18 years, thereabout. So if, let's say, what the petitioner has put before the commission, if it is allowed, what do you think the implication will be on the industry?
Well, I mean, I guess certainly there's a matter of what are reasonable well costs, and a lot of those decisions could be reviewed. I mean, as far as revoking our pooling order, I don't. I think that the division has a process for parties to review well costs and petition those, and for the division to determine whether they are, appropriate or not. And so I don't know that our pooling order should be revoked because our well costs are not deemed appropriate.
Thanks so much, Madam Chair. I do not have any further questions.
Thank you. Commissioner Bloom, do you have questions for the witness?
Sure, Madam Chair, thank you. A couple questions. Thank you for your testimony, Mr. Marcoux. I think I'll ask both these questions to you and Mr. Robb, since you're covering overlapping territory here. So you provided an AFE for $9 million to the OCD for the 15 Penn wells, and then one that was some $3 million more was sent out to the potential partners in the in that. Is this appropriate under OCD regulation?
I think my understanding of the AFE that Mewburn submitted in case 20809, the one you're referring to, that was $9 million. Our interpretation of that AFE is that it was the cost going forward to drill that particular 1510 2H well. I believe that we had tried to reopen case 20580, and so that that is why this is an amended order with just a different case number. And so then all of the wells are included under this new amended order, but it was the costs for drilling that well going forward. And so then when we submitted those costs to Mr. Ragsdale, that second AFE, incorporates all of the costs that had been, incurred and then were estimated in that second AFE.
Do I follow you? Did you ask the OCD for permission to pass along those costs that push the price up, push the AFE up to $12 million plus?
Specifically, I did not. I was not part of that hearing, but I do believe that Mr. Bruce asked for the costs of all of the wells to be incorporated in the order.
One phenomena that concerns me in government or as a government regulator is privatizing, essentially allowing profit to pool in one area and then costs to be spread out or socialized. To your knowledge, Mr. Cood, have you seen this precedent before of junk wells drilled with no order being added to the cost of forced pooled orders?
I'm trying to follow your question here. I guess we did force pool the initial wells, and we had to spud those before the order was issued. I think it was a number of months from when the original case was heard to when the actual order was issued. And then even within that time frame before the order was issued for the original case, we reopened that case, which then became case 20809. And so, I don't know if this particular instance has, ever been discussed. I don't know any history on that.
Good, thank you. No further questions at this time. Thanks.
Thanks, Commissioner Bloom. Okay, I have quite a few questions. Okay, can you remind me again the dates the initial wells were drilled? The ones that failed, the 1015s?
Yes, ma'am. We spud the initial wells, or the initial 1015 2H July 7th of 2019. And I believe it was July 24th of 2019 that we plugged that well, and then we commenced the 1015 2HY on July 26th.
Okay. So I'm looking at the original order R20924. So this originally went before the examiner on June 27th of 2019. So less than a week after that hearing, you spud the wells initially, correct?
Yeah, I guess that would be, what, about 10 days?
Do you know when the original application was filed?
I do not have that in front of me. I know Mr. Rob would have that information.
Okay. And this may be a question for Mr. Bruce, but Would it not be a violation of the division's rules to move forward in spudding wells that you don't have all of the appropriate permits for yet?
Well, I do think, sorry, go ahead, Jim.
Madam Chair, first of all, and this was what I was going to say a little earlier, is that if you look at the pooling statute, 70-2-17.c states that an interest owner who has the right to drill, who has drilled or proposes to drill a well on a well unit can apply to the division for a pooling order. You can pool before, during, or after a well is drilled under the statute. And I don't have it in front of me, but there is case law from other states that says the same thing. Furthermore, there is a case, New Mexico Supreme Court case, Bellet versus Greinberg, which is 114 New Mexico 690, in which Mr. Greinberg, who was a person of some notoriety in past New Mexico oil and gas history, owned, operated wells on certain tracts, and he had other interest owners in the tracts. And he went ahead and did some work on wells, either drilling or reworking, without force pooling or anything. And the court said those people are liable, the other interest owners are liable for the reasonable well costs incurred by the operator of the well. So there's a difference. You absolutely have to get the APD, the application for permit to drill, before commencing. But the thing is, obviously, for state and federal state and fee lands, you get that through the Oil Conservation Division. For federal lands, you got to go through the BLM. And yes, you need to get those APDs, but it is not illegal to commence a well before getting a pooling order or before getting everybody signed up to a JOA.
And so I just want to make sure I'm understanding what you're representing. Under the 7217C, it allows you to move ahead and start drilling before you have a pooling order, and you can get that pooling order at any point in time?
Yes, I usually, of course, the procedure is to get the pooling order before you commence drilling, but I've been getting pooling orders just because of certain time deadlines, which Mewburn had in this case, while a well was drilling, and even long after a couple of wells were drilled, just due to various title issues and things like that. But you know, when it comes to just drilling a well, as long as you own an interest in a well unit, you can drill a well. And you can seek to recover costs incurred in drilling that well from the other working interest owners. And there was, go ahead.
Madam Chair, I'm going to object so long, and I won't interfere other than to say I would like the opportunity to address these very principles that Mr. Bruce is espousing at this time.
That's fine. I'll give you an opportunity. Yes.
Thank you.
Absolutely.
The only other thing I would say is that there was a big fight among several operators over in Lee County. This must have been, I could look it up, and it involved, like I said, 3 or 4 different parties, but it was a mess. and it went up to the commission, and the commission order in this case said that you can, it basically said you have to own an interest in each quarter section in the well unit in order to drill a well, in order to commence a well, but you don't need a pooling order beforehand. And that was upheld in Lee County District Court.
Do you have a order number for that, or?
I do not, because it just popped into my head right now. It was a, I can get the OCD case number, and which would, at that point, it would be the same case number before the commission. I will look into that and get that case number for you, but I do not have it off the top of my head. It was probably 2006 or something, 15 years ago at least.
So a couple years before my time here.
Yeah. many years before your time here.
Okay, yeah, that would be helpful. And Ms. Shaheen, my plan would be to kind of finish through Mewburn, and then I'll give you another opportunity, and we may have additional questions for Mr. Ragsdale. Okay. So basically, it sounds like, as you represent the law and statutes, Mewburn was well within their rights to have moved forward prior to having the pooling order.
Yes, I believe that's our position.
Okay. All right. Okay, I want to talk a little bit about substitute wells. I think, or what are we called? Let me pull up the right citation. Okay, a substitute well, what it has to be with 330 feet and 10 days. And you said in your testimony, I believe, that you considered the mirror well, to be within 330 feet. Can you explain that to me, please?
Yeah, absolutely. So, we certainly have surface locations. I know, many of times you can obviously also surface off lease and drill onto your lease. And so our interpretation here is that the completed interval of the wellbore, being, drilled 2 miles in a direction, underneath the earth, complies with that statute, that the original first take point, being our first perfed part of the lateral, was originally 100 feet from north line and 450 feet from east line. And the bottom hole location, which, also in many cases is your last take point, was 100 feet from south line, 15, and 450 feet from the east line. When we moved the well location to the south line of section 15 to drill north, our last take point, or excuse me, our first tank point was now 100 feet from south line, 450 feet from east line of 15, and 100 feet from the north line and 450 feet from the east line of 10. And so from that standpoint, I mean, we were basically, the TBDs were all the same. We're drilling in the first Bone Spring sand. We never got there coming from the north, but we drilled the exact same lateral in the first Bone Spring sand coming from the south. So our completed wellbore certainly complies with this.
So you're interpreting the rule to be 330 feet from the wellbore, not the surface location?
Yes, ma'am, Madam Chair.
Are you familiar with any case law or previous division orders on substitute wells and what the division has previously considered a substitute well?
Personally, I'm not. No.
Mr. Bruce, are you?
No.
Okay. So I think these division rules were written a while ago. When generally was the transition from vertical to horizontal wells within the oil and gas industry? I know it was a time period, but kind of when was general adoption of horizontal over vertical, or preference?
I would say that for New Mexico, probably, sometime around 2012, you really started to transition from vertical drilling to horizontal drilling.
Madam Chair, Jim Bruce again. I know I have a case that I did sometime for an old client. That's pretty accurate. I think the initial few horizontal wells were short horizontals drilled in Lee County in about 2009 or 2010.
Okay. So I'm looking at the date on this. It looks like it was effective 12/1 of 2008, which would have been prior to horizontal well prevalence in the state. Do you think that this rule translates to horizontal wells, or is it written in a way that mostly makes sense for vertical?
Who are you addressing?
Sorry, Mr. Hugh.
Yeah, I think we would view that it's a little bit dated. I think that Mewburn drilled the same well in the same pooled formation in the same drilling unit, and really, I mean, at the same footages. And so, I mean, under that concept, it is a replacement well. I think that the timing required under this statute, in just the modern business, isn't always, I don't know that operators could always comply with that. We are only able to walk a rig, 150 feet, so not even 330 feet here. And just the size of the rigs these days, everything that's involved. If you were to move a rig, this may or may not be possible.
Okay. So it looks like originally you did for the second well, so you originally spud the 2H on July 7th, plugged July 24th. 2HY was spud on July 26th. When was the order was there an application date for the 1510? I think I have that as 9/3. So September 3rd. Is that correct?
Yes, Madam Chair, I have the same date.
Was there, so I think earlier you said this is federal land. Is that correct?
Yes, it's, I believe it's federal surface as well, but it's certainly 100% federal minerals.
Okay.
We have to have federal permits for both the wells coming from the north and both the wells coming from the south.
Do you know what the timing was for any of those applications? So what I'm trying to understand is, so the 2HY, you then spud it on the 26th. When was that plugged?
I don't have the exact date in front of me, but it would have been in August. And then I know that we filed for APDs, for new APDs coming from the south, August 27th of 2019. And that would have been within 10 days of when we plugged the 1015 2HY. And so
Do you think you
I
can find that date?
uh,
The plug date of the 2HY?
I'm trying to think here.
Or if you can
I may have misspoke. I think we staked the well on August 13th of 2019. And on the August 10th, we staked the well. We plugged the 1015 2HY on August 3rd.
Okay, so it was plugged on August 3rd.
Yeah, staked on the new wells were staked on August 10th. We have to get plats back from the surveyors, and our federal APD filled out, and we submitted that on August 27th.
Okay, let's see if I get this right. For the 1510s. Jeez. So you.
I'm sorry. I apologize. I was able to get my well file here to have these specific dates. So, do you have when the 1015 was plugged? But for the 1510 2H, we staked the well August 6th of 2019. We had an on-site with the BLM August 16th of 2019, and then we filed the APD for that well August 28th of 2019. And the original 1015 2HY was plugged on August 3rd.
Okay. Were any notifications made to the division regarding, it sounds like you communicated, oh my God. I'm sorry. My computer says it's going to restart for a third time, but instead of giving me an hour and a half, it's giving me 15 minutes this time. I give up in a moment. I'm sorry, Mr. Coon. I'm sorry guys, but let me get to I have more questions, but let me get to kind of a whole point really quick, and then I'm gonna have to reboot again. And I will come back. But okay, so so the 2HY for the 1015 was plugged August 3rd. And then I think my question was, did you make any notifications to the division regarding your plans, the status, any of those pieces?
I do not know off the top of my head.
Okay. But for all intents and purposes, I guess there is no way that you could have commenced drilling within 10 days of the well abandonment because you would have been out of compliance due to, because you basically have to go through a new federal process because the surface location was further away.
Yes, Madam Chair, that's correct. I suppose that Mewburn could have made a third attempt on the original pad, third, fourth, fifth, on the original pad, to continue to try and drill a successful well from that location. But in the process of all of this, we determined that it would, be like, I think, like we previously testified, we've drilled 8 other wells at the time we had drilled 6 other wells in these 2 sections. We had never had an issue like this, and so rather than continuing at the same location, we flipped to the south line of section 15 to drill a replacement well. And correct, there's absolutely no possible way to do that within 10 days.
Okay.
Because of I mean, if it was a state permit, if it was a fee permit, it is possible. We probably could have done that, but being a federal well, their approval process, is not that quick.
Okay. I have more questions, slightly different questions than this line of questioning, and my computer is apparently going to self-destruct in a moment. So why don't we, I apologize, guys, take a 5-minute break. It's 2:03. Let's come back at 2:08, assuming this doesn't take too long. Mr. Moulander, I'm going to give you hosting abilities for the 3rd time today. And we will be back shortly. Sorry, all.
No problem, Madam Chair.
All right, Mr. Cood. So going to cost pieces, I guess I'm wondering what would have happened if, so the first 2 10-15 wells, the 2H and the 2HY failed. What would have happened if you had just stopped at that point, decided this is not worth our effort anywhere? We're walking away from this area. There are clearly problems. What would have happened to the costs? Would they have still gotten passed on?
Yes, I mean, if we had stopped, I suppose that they would have been passed on to all of the parties that either elected under the JOA or participated under a pooling order, as to their interest in the well.
So there potentially would have been a world where the cost would have gotten passed on, but the parties wouldn't have been making any money, so they would have just had to pay?
Yes, absolutely.
So overall, well, never mind. Okay. Have you had other wells that have failed similar to this?
Luckily, Mewburn Oil Company doesn't make a habit out of junking and abandoning wells, or we probably wouldn't be sitting here. But yeah, I mean, it's absolutely part of the business, and we have instances where we have to junk the hole and start again. I can't think of any time in my career here with Mewburn that we have had any issues in the vertical part of a hole and never seen it through to completion. I mean, we always continue the operation uh, and get the well to TD as well as possible.
Okay. In situations where you have had to junk the wells, as you said, what has happened? Have you had any situations where you've done anything identical to this, where you basically moved over and did mirror wells, as you've termed them?
Um, I'm not sure. I guess just maybe to clarify a little bit here, I think on our second attempt, the 1015 2HY, you know, we ran an extra string of casing to try and mitigate the issue that we had in the 1015 2H, and we still had issues. When we moved the location, we certainly analyzed the shallow drilling hazard that we were having an issue with, but I wouldn't say that it was the same formation that we were losing circulation in on the 1015 wells still was present in the 1510. It just wasn't quite as thick, and as we mentioned before, we had drilled other wells in these sections and had never encountered that problem. But I mean, just specifically to your question too, I don't know that we've ever had this occur to where we just weren't able to drill the vertical portion of that hole and had to flip the locations, to my knowledge.
So there are no other sort of instances within Mewburn where you could point to how you managed the costs in a similar situation?
Not this exact particular situation, no.
Are you familiar with any other situations similar to this that other operators may have had, and how they managed the costs?
Personally, I am not, no.
Okay. I think that's all I had for questions. Do any of the commissioners have more questions before I let Mr. Bruce redirect?
Madam Chair.
Okay.
Yeah, Madam Chair, one quick one. So
Go ahead.
I really want Mr. Bruce to state again the regulation that says that either drilled or proposed to drill, you can force pull without the approval of the order or before the approval of the order. Can he state that one more time?
Can we what? Excuse me?
Yeah, can you, so you quoted a regulation that states that either you decide whether once you get the APD, you can drill, during or at a time where you are still trying to get the pooling order approved. Can you state that regulation one more time?
That's it. That's in the New Mexico Oil and Gas Act, section 70-2.17.c. It explicitly states that.
Thank you. I appreciate that. Thank you, Madam Chair.
May I ask a couple of follow-up questions for Mr. Cude?
I was muted. I said, yes, absolutely. Go ahead. Sorry.
Before I begin, just very briefly, Madam Chair, I know you were putting together a timeline, and I looked at my computer, and one of your questions was when these applications were filed, the original 2 applications. And if anybody wants these applications, I can email them to them in Word so they can see the document creation date. But the 1015 Wells application was, I created it on May 14 of 2019. And it was filed on or about then because you have to file 30 days ahead of the hearing. And then the 1510 application was created by me on September 3, 2019.
Thank you. And I'm not sure if I was still muted when I said it, but I did say after Dr. Rampoma finished that I am still interested to see if you've got those orders you can dig up. I'm not sure if I was muted or not.
I was in contact via text with one of my clients, and the commission order I'm talking about, I will have to look it up, but I have the well name now and I know where it's located. And, but I don't think I'll have the time to locate it. I'll do it in the hearing, but I may. Let me find out. Mr. Cood, one thing you mentioned on this timeline, you talked about getting the well staked. When you file an application for permit to drill with the BLM, first, they won't let you file an application for permit to drill until you get the well staked and the surface location approved. Is that correct?
Yes, sir.
So there's a little lag between getting the location staked and then getting all the other documents together for the usual 50-page long federal APD.
Yes, sir, that's correct. And then a BLM on-site on the location with our natural resource specialists to approve the location.
Then the only other question I have is, I mean, there are situations where you stated where Mewburn has had well costs, some problems in drilling. Would it be Mewburn's practice to pass on these increased costs if they were reasonably incurred in well operations?
Yes.
And let me check. Madam Chair, I think that's it.
Thank you. All right, Mr. Well, actually, Mr. Melander, is there a specific term in case we have additional questions for Mr. Q later?
No, just you're not releasing them from their appearance today. So if you want to recall them,
Okay.
you can reserve the right to do that.
Okay, thank you. For the moment, we are done with questions, Mr. Q. Mr. Bruce, would you like to call your next witness?
Yes, I would. Mr. Mitch Robb. And if he could be sworn in, please.
I think they're switching chairs. All right, I think Mr. Robb, can we hear you?
Yes, can you hear me?
Yeah, perfect.
Perfect.
All right, Ms. McFarland, would you please swear the witness in?
Mr. Robb, this is Mary McFarland, the court reporter. Would you raise your right hand, please? Thank you. Do you solemnly swear under penalty of law the testimony you are about to give will be the truth, the whole truth, nothing but the truth?
Yes.
Thank you.
Mr. Robb, please state your name for the record.
My name is Mitch Robb, or Mitchell Robb.
And who do you work for and in what capacity?
I'm a landman with Mewburn Oil Company.
Have you previously testified before the division, not the commission?
No, this is my first time.
No. Have you previously testified before the division?
Oh, the division,
OC.
yes. Yes,
And as a landman, correct?
correct.
And were your credentials as an expert petroleum landman accepted as a matter of record?
They were.
But you have not testified before the commission.
That is correct.
Could you, first of all, submit it as Exhibit 2 as your self-affirmed statement? Well, let's get into it. You do give a little of your educational employment background, but could you state for the commissioners what your experience is, especially with respect to Mewburn?
So yes, I've been with Mewburn since early 2015 and working the Permian since late 15. And I've proposed many wells, gone through countless pooling applications for the past 7 years.
Okay, and does that include, besides the pooling and the well proposals, working on JOAs, joint operating agreements?
Yes, sending out proposals, working on JOAs, all the pertinent agreements that we have to put together for the wells.
And are you familiar with the land matters
Sorry,
involved?
Mr. Bruce, I'm sorry. The witness's voice just faded away towards the end of the sentence there. I got proposals working on JOAs, all pertinent something.
Pertinent
Oh,
documents related to the wells. Sorry.
Yeah. Answer my question again, Mr. Robb, about working on JOAs as well as well proposals, et cetera.
Yes, I've sent out well proposals, JOAs, and all pertinent documents and contracts related to the drilling of wells.
And are you familiar with the Mewburn's land matters involved in this particular case?
Yes, I am.
Madam Chair, I tender Mr. Robb as an expert petroleum landman.
Ms. Shaheen, do you have any objections to that?
No objections.
Do the commissioners have any questions about Mr. Robb's credentials?
No, Madam Chair.
No, Madam Chair.
Thank you. Mr. Robb is an expert as a petroleum landman for the purposes of this hearing.
Thank you. And Mr. Robb, I'll get into some questions. But first of all, your self-affirmed statement has been marked and submitted as Exhibit 2. Did you prepare that statement?
Yes, I did.
And were the exhibits that are attached to the statement either prepared by you under your direction or compiled from company business records?
Yes, they were.
Okay. And do you adopt this self-affirmed statement as your testimony, basic testimony in this case?
Yes, I did.
Let's get on to a question that was raised to Mr. Cute.
Mr. Bruce, do we need to enter the exhibits into the record?
Okay, I move the admission of Exhibit 2 into the record, Madam Chair.
Thank you. Ms. Shaheen, do you have any objections?
No objection.
Thank you. Commissioners, any questions or objections?
Madam Chair.
No, Madam Chair.
Thank you. Move Mewburn Exhibit 2 into the record. All right,
Thank
please
you.
proceed, Mr. Bruce.
Mr. Robb, I'll get into a couple of questions that were also asked of Mr. Cood. Regarding after the second wellbore was junked, you had to, and you decided to move the well location, you had to go to the BLM, correct? To get approval for the new location, surface location.
Yes.
And really the OCD, whenever those federal lands are involved like this, the OCD really doesn't have any approval authority over a federal APD. Is that correct?
Yes, that is correct.
The OCD waits until the BLM approves the APD. The OCD does approve an API number for the APD once it's approved by the BLM. Is that correct?
Yes.
Okay. Secondly, regarding some questions I think raised by Ms. Shaheen about first and last take points. First of all, the surface hole location really has nothing to do these days because of land use, and surface locations has very little to do with the first take point. Is that correct?
Yes, that is correct.
And you were listening to Mr. Q testify, were you not?
Yes, I was.
And he said you go to that drilling, horizontal drilling proposal, and you can figure out the first take point from that document. Is that correct?
Yes, that's correct.
So the surface hole location is rarely equivalent to the first take point. In other words, does Mewburn and other operators get a surface location and they might drill?
Oh, no, sorry, I understand the question now.
Yeah.
No, the service location is not always exactly where the first take point is going to be once we reach our TVD.
So Mr. Kood testified about the first take point. The bottom hole location or last take point, if you look at would that be on the Form C-102s, the last take point?
Yes.
And I'm looking at it. It's one of the, I don't know exact page number right now. It's actually on page 138 of the exhibits submitted by Mr. Ragsdale. If you looked at that, it was this is not the real well at issue, but it's the IBEX 1510 B3PA1H, the other well. And I'm looking at it, and it shows the bottom hole location. Now, the setbacks are 100 feet on these horizontal wells, are they not, from the end of for the end of the producing interval?
Yes, 100 foot from the section or quarter line.
So I'm looking at that particular page, and it shows the bottom hole location 100 feet from the north line and 600 feet from the east line of section 10. Another way to get a good estimation of the first take point would just be to go straight south from that location to 100 feet from the south line of section 15. Would that be a good approximation?
Yes.
Okay. Okay. Let's go on to something else. During the original hearing in this matter, you attended the hearing. Is that correct?
Correct.
And did you listen to the testimony of Karen Stanford?
Yes.
And she testified about when Mr. Ragsdale learned of the junked holes, did she not?
Correct.
And what did she testify to as an approximate date for learning of the junked holes?
I'm going to object to this question because Mr. Ragsdale has already testified about this. And I don't believe that Ms. Stanford's previous testimony before the division in a de novo case before the commission is relevant at this point. Mr. Ragsdale already testified here today.
Relevant. I think it's relevant. Mr. Ragsdale said he didn't know anything about it until March. And you're trying to establish a timeline of when he decided to raise these issues. And
That's right.
so,
I'm sorry. Go ahead, Jim.
Was there more to that statement, Mr. Bruce?
Madam Chair, if I could, Exhibit 3, Mewburn Exhibit 3 is the division's order in this matter. And on finding paragraph 29, the division found that Mr. Ragsdale was aware of the status of the 1015 and the 1510 wells in September 2019 based on the testimony of Karen Stanford, and it does give the transcript pages where she testified about that.
So, Mr. Bruce, I think, you know, Ms. Shaheen has a point. This is a de novo hearing. I understand, I think, where your line of questioning is going, and maybe if you rephrase to refer to the orders or hearing documents, that might be more appropriate.
Okay. That'll be fine.
If I may, again, even with respect to the order, this is a de novo proceeding, and I don't think the commission is bound by any finding made by the division. And this is in particularly due, and if I recall from the transcript, Ms. Stanford wasn't sure about when Mr. Ragsdale knew about the junked wells. And she eventually said, well, I think it was at some point in September, something to that effect, if you look at the transcript. But today we have Mr. Ragsdale talking about his personal knowledge. So that would be more reliable than Ms. Stanford's testimony. And I don't believe, again, that a finding made by the division based on Ms. Stanford's testimony is relevant here.
Madam Chair, let me address that quickly. De novo means that essentially this is a fresh slate and that the commission would have to consider evidence provided today because it is a brand new evidentiary hearing.
Thank you, Mr. Moander. Mr. Bruce, can you reframe your questions or move on to a different line of questioning?
I will just move along here, Madam Chair.
Thanks.
Going on, let me get the exact exhibit number. Mr. Robb, in your affidavit, you testify and you attach attachment G to your statement, your self-affirmed statement. Letter dated March 5, 2020 to Mr. Ragsdale, including the pooling order and requesting him to make an election. Is that your letter?
Yes, this is my letter.
Okay. And Mr. Ragsdale testified that Karen Stanford did call you, or you called her, which occurred?
I believe she called me first. We played a little phone tag, and then finally got on the line with each other. I believe her note says on the 18th.
And you did speak with her personally, correct?
Yes, I did.
In talking to you, did she object to these additional well costs from the junked holes?
No, so we probably talked about this for 5 minutes. She called and asked why these costs were included, because if you look at my letter, which is, I think, Exhibit 5 in their files and Attachment G and ours, it says that this AFE includes the estimated cost for the well and realized cost of drilling, plugging, and abandoning the first 2 attempts. And she had some questions about that and why we included those. And I explained it was because they were replacement wells or substitute wells for the initial well, and that this new 1510 B1PA FedCom number 2H was a replacement to that those first 2 wells that we junked. It kind of explained our reasoning behind it. And then she wasn't very familiar on the legality of that. So that's when I referred her to Mr. Bruce or to any other attorney that she could talk to.
And that letter you attached at the back is you sent that letter certified mail, correct?
Yes.
And
overnight.
So that would be the second page of Exhibit G, shows that it was delivered on March 10, 2020.
Yes, correct.
Is that correct?
Yes.
So what was the deadline for Mr. Ragsdale to elect to join in the 2 wells?
I believe it was April 10th.
Did he do so?
No, he did not. He missed his election under the terms of the polling order.
And during that period of time, during that month, 30-day period, did he object? To your knowledge, did he object with Mewburn about the well costs?
No, we did not receive any objection to it.
And even though he did not make a timely election, therefore, was he considered non-consent in both wells?
Yes, he was.
But Mewburn gave him the opportunity to join in both wells. Is that correct?
Yes, by Mr. Insulaco's letter.
Insulaco?
Yes.
And he did elect and pay on the 3rd Bone Spring well, the well that's not an issue here today.
Yes, we set out certain conditions under that letter, and he met those conditions on the 1510 1H, but did not meet those on the 1510 2H. And this was all after he was deemed non-consent under the original order.
And you could have just held the interest as a non-consent interest, and that his interest would have been shared among you and perhaps other participating working interest owners. Is that the way it goes?
Yes, so since he didn't send his election in by April 10th, that was deemed non-consent. He then sent us a letter, and in an attempt to work something out, we said, yes, you can participate with us, and you'll be deemed consenting under the polling order if you pay the estimated cost of the AFEs that we sent. So we did try to work something out. He did not meet the conditions on the 1510 2H, so we did not allow him to participate.
And the election to participate, does that take a long time?
No, he just has to sign an AFE and send it back to me.
Sign the AFE indicating, yeah, that he does elect to join voluntarily in the well.
Correct. And that could be sent by email, mail, anything.
No, there's no particular way it needs to be sent. It doesn't need to be sent certified or FedEx or anything.
No, I just have to receive it within that date. Even if he mailed it and it had a stamp within that 30-day period, I would still count it.
How many working interest owners are there in this well?
It's around 50.
Are most of them subject to a JOA?
Yes, they are.
And are all of them bearing their proportionate share of the junked hole costs?
Yes.
So Mr. Ragsdale isn't being treated differently than any other working interest owner, is he?
No, they all have to share in that cost.
The other thing is, you know, the questions have come up about Mewburn filing for the pooling application and having the hearing, but then commencing the well, did Mewburn have drilling obligations?
Yes, we did.
Was it leases or term assignments or what?
These are all term assignments. I believe all the base leases were held.
So if you hadn't commenced drilling the well in a timely manner, you could have lost a chunk of your interest. Is that correct?
Yes, that's correct.
And what is the approximate percentage interest in the well unit owned by Mewburn Oil Company?
I believe it's around 35%.
And what about Mewburn and all of its JOA working interest partners?
Shoot, that's going to be closer to, I think it depends on the well, but I mean, it's closer to 90.
90%. And they were all kept informed of what was going on with these wells, is that correct?
That is correct.
But is it the industry standard not to disperse well information to people who have not joined in a well and paid their proportionate share?
That's correct. We only send information to parties that have elected to participate with us, either under a JOA or pooling order. We don't just randomly send out information to people.
Do you believe that you, and particularly in Mewburn, worked with Mr. Ragsdale in good faith to get him to join in these wells?
Yes, we did.
Whenever Mr. Ragsdale or Karen Stanford asked for information, did you give them the information?
What information, I guess?
When they started questioning well cost, did you withhold any information from them?
Oh, no.
And he never raised, did he ever raise an objection about the costs of the 1510 2H well until after his failure to elect in the well?
Yes, I believe we received that by a letter dated April 15th. Not
Okay.
mistaken.
So a month later.
Yeah, over a month.
Or no, several days after the election period expired.
Correct.
Have any other working interest owners objected to the AFE for the 1510 2H well?
No, they haven't.
Did Mr. Ragsdale ever forget that he's objecting to the inclusion of their costs in the 1510 well, but has he ever questioned the reasonableness of the costs incurred in the 2 junked wells?
No. I guess until this hearing.
Sorry, he hasn't told you what? Mr. Bruce is turning pages. He hasn't told you what? He said, no, he hasn't told us something.
Uh,
Did you say until this hearing?
Told us what?
Mr. Robb, I think you said he hasn't really raised it until this application, this hearing.
yes, yes. That's what I said.
Thank you.
I'm almost done here, Madam Chair. Just let me check my notes.
Okay, thanks.
And in your opinion, is the only difference between the 1015 wells and the 1510 wells is the north-south versus south-north orientation?
Correct.
Madam Chair, I believe I'm finished with the witness at this time. I may have some redirect, but thank you very much.
Okay, thank you. Ms. Shaheen, do you have
Yes,
questions for the witness?
yes, I do.
All right, go ahead, please.
I think I'd like to start by addressing some of the testimony that Mr. Bruce elicited, and then I'll turn to Mr. Robb's self-affirmed statement. Good afternoon, Mr. Robb.
Good afternoon.
Nice to see you again.
Too.
You testified and you included in your self-affirmed statement the proposition that Mr. Ragsdale did not object to those costs for the junked wells prior to the time for election. You recall that testimony?
Yes.
And you recall your statement and your affirmation at paragraph 13. Is that correct?
Yes.
And yet you did talk with Ms. Stanford contemporaneously with the election letter that went out March 5th, which was received March 10th, didn't you?
Yes.
And were you present when today when Mr. Ragsdale went over his exhibits 8 and 9?
Yes.
And I'll pull those up for you. So let's see if I can find those here.
I've got him here.
Well, I need them too. Hold on one sec. It's actually exhibits 6 and 7. Here we have the email chain with Ms. Stanford on March 11th. Do you see that?
Yes.
And I mean, her last email says, I'm trying to understand why you're including what she terms as the P&A cost of the first well. I mean, do you not consider that an objection to the costs that were imposed?
I consider it a question.
Okay.
She didn't state in there that she was objecting to the costs.
So you're literally requiring her to state in writing that she objects in her email. You don't consider her questions about it to constitute an objection?
I don't consider a question an objection.
And when you spoke to her the next day, did you resolve that issue with her?
No, I explained my side. She said she was going to go talk to Mr. Ragsdale. And that's kind of where it left.
So you agree that the issue was not resolved. The issue that Ms. Stanford raised on March 11th was not resolved during that 30-day election period. Is that correct?
She never called me back. I explained our side. She said, okay, let me go talk to Mr. Ragsdale. Never called back.
And so you consider the fact that she never called back to constitute a non-objection? Is that the way you've characterized it?
Yes, I explained our reasoning. She said, okay, let me go talk to Mr. Ragsdale. Never called back. So
And
I
apparently,
take that as she looked like they talked about what I said. They didn't object after that, or even at the time. So I don't see that as an objection, no.
did you feel that you had adequately explained the issue to her?
To my best of ability, yes.
And do you feel like she was satisfied with your explanation?
She never called back. I wasn't sure if she called Mr. Bruce or consulted an attorney, but I never heard from her, so I took that as she was satisfied.
So you assumed, is that correct?
I didn't hear anything back. So based on our conversation, yes.
Did you ever talk to Mr. Bruce and ask him whether Miss Stanford had called him?
No, I did not.
Why not?
Is that, I don't know why I need to call Mr. Bruce to see if he talked to someone.
Do you regularly refer other working interest owners to your outside counsel for advice?
When they ask
Or for-
about if we can do that under a pooling order, then yes. I would in any other case.
So you have no affirmative communication from Miss Stanford or from Mr. Ragsdale that they didn't continue to question the estimated cost, do you?
They never sent me an objection, so no.
Okay, so the answer to my question is no, you never received an affirmative statement saying that they no longer objected.
I never received an objection, is what I'm saying.
And you don't consider her questioning the cost to be an objection to the cost?
I consider it a question. I explained it. She talked to Mr. Ragsdale, or said she would, and I heard nothing back. If they would have objected, I feel like I would have heard something back.
You also talked about certain conditions. And the certain condition here is actually the estimated cost to which Ms. Stanford objected to. correct you, the certain conditions were that Mr. Ragsdale had to pay those estimated costs, they had to pay the actual costs for the junked wells to be able to participate. Is that correct?
So after Mr. Ragsdale missed his election period under the pooling order, he sent us that letter. And then we sent him a letter that he would have to pay all of the estimated costs under the pooling order. Because he objected to that in that letter. And then, yes, we told him he had to pay all the estimated costs under the pooling order.
So my point is your conditions were that he comply with a requirement that he had objected to. Is that correct?
This letter was given as a favor. His interest was already deemed non-consent.
I don't think, I don't think you're answering my question.
Sorry, could you repeat it?
The conditions that you imposed on Mr. Ragsdale were the exact condition that he was objecting to. Is that right?
Yes, that he paid the cost of the wells.
Okay, thank you. You also testified previously, or Mr. Bruce suggested that you may have shared non-consent interests with other working interest parties who were voluntarily participating in the well. Do you recall that testimony?
I don't believe I said that.
If I recall correctly, Mr. Bruce asked you that about the non-consent interest that would be claimed by Mewburn, or perhaps, was his language, perhaps shared with other working interest owners. Do you recall his questioning in that regard?
Yes, so under the terms of the joint operating agreement, if a consent or a JOA partner goes non-consent in the drilling of the wells, then we would send out elections to JOA partners, and then they would have the option to pick up their proportionate share of that non-consenting interest.
And do you limit that to parties who are participating under the JOA?
Yes, because it's a provision of the JOA.
So that you don't share those interests with parties who are participating under the forced pooling order?
Correct, because they're not a party to the contract that governs that non-consent share.
You also testified about the number of working interest owners previously. Do you recall that testimony?
Yes.
And I am going to direct you to an exhibit that's part of Exhibit 4. Let me see if I can pull that up real quick. And now I'm going to share my screen. Can you see that?
Yes, I can.
Do you recognize this?
Yes.
Can you tell the commissioners what this is?
That is my tract ownership for the spacing unit of the 2 ibex wells in question, and the ownership of said spacing unit.
And in paragraph 4 of your self-affirmed statement, you state that a pooling application was filed against him, Mr. Ragsdale, and other parties in case number 20580. That would actually pertain to a different tract ownership. But this was the case as well in case number 20809. Is that right?
Yes.
And the tract ownership here that we were looking at is the tract ownership from 20809.
Yes.
And are these the other parties that were force pooled in this matter? Which parties here were force pooled?
All parties with the asterisk. There's a little footnote at the bottom that shows.
Okay, so and how many of those were actually pooled?
Two, three, 6, 7, 8, 9, 10, 11, 12, 13. There's 21 names on there.
21 names. So the total, you have represented here that the total interest is being force pooled is 9.4%. Do you see that?
Yes.
Have you calculated what the percentage of interest owners is that is being force pooled here?
About 9.4%.
Well, that's the total interest being force pooled, but the number of parties being force pooled out of 20, it's approximately.
So all these parties with zeros by them,
Uh-huh.
those are all record title owners that are being force pooled. They're not working interest owners in these wells. So parties with working interests, it amounts to 12.
Okay, so out of Mewburn and Challenger, which are parties that own 90%, then we have another 12 who were actually force pooled. Is that right?
Correct.
So you would be force pooling approximately 86% of the interest owners in this well?
No, it says 9.4.
Well, that's the interest, but I'm talking about the interest owners. How many parties were force pooled?
I just said it. 1, 2, 3, 4, 5, 6, 7, 8, 10, 12.
Right. And so my point is the percentage of parties that were pooled is approximately 86%. Do you understand what I'm?
Where does what's the 86? How do you get there?
Well, you've got two parties here.
No, that's Mewburn Oil Company operator Challenger Crude Limited et al.
And
so there's 50 parties total, 12 were pooled. Is that 38 roughly?
38% of the interest owners. That's
38. There's, I don't know exactly the number, but it's roughly 38 parties make up that 90%. That's what the et al. Is for.
Okay, so my next question relates to these other pooled parties. Did they all receive an AFE that had been adjusted by adding the inflated cost?
Yes.
Or the cost for the junked wells?
Yes.
And how many of those voluntarily participated in the well?
All of the parties that were locatable outside of Mr. Ragsdale, I'd have to check the number, but it's a majority.
How many were unlocatable?
I'm not sure.
So your testimony today is that all of these parties who were force pooled, except for those who were unlocatable, voluntarily participated.
Or that didn't respond. Every party that I sent this to that participated under the terms of the pooling order accepted those costs.
And how many of these force pooled parties voluntarily participated?
Like I said, I'm not sure. It's not in these files, but
who would know?
I would know if I had the right files.
Uh-huh. Could you ballpark it?
7, 8 of the parties participated.
I'm sorry, you said 7 other parties participated?
7 or 8. Yeah. Just
7 or 8 of the 12?
of the 12.
And it seems here that Mr. Ragsdale has the greater interest of all those parties that were force pulled. Is that right?
Yes,
He's got 4.89%.
correct.
Ms. Shaheen, I think we've kind of been on this line of questions for a little while, and it's unclear to me as to the relevance. If you could maybe try to frame the questions in a way where it's, I think, relevant to the case at hand.
Yes, I will happily do that. I think this goes to Mr. Rob's testimony that no other parties objected to those estimated costs. And, or excuse me, to the addition of the cost for the junked wells on the estimated cost. That's what this line of questioning goes to. I'm obviously not doing a very good job of linking it. I think maybe we should go to his self-affirmed statement and walk through that. That might be the best way to tie it to his testimony. So I'm going to go to his self-affirmed statement. Do you see that there?
Yes.
Okay, so this goes to paragraph 4. The pooling application was filed against him and other parties in case number 20580, and as Mr. Rob testified, also in case number 20809. Turning to your paragraph 6, here you testify that due to drilling issues, the original case was reopened in case number 20809. Does the application in case number 20809 explain that you were reopening case number 20580?
You have a copy of the application? Is that in the exhibits here?
I don't. You don't recall what was in the application?
I didn't prepare the application.
Did you provide Mr. Bruce with the information to prepare the application?
With the parties, yes.
Let me see, I can pull that up pretty quickly here.
Just so you know, we can see your screen.
Oh, that's good. You're gonna,
Okay.
I'm gonna take you to the application here, is my hope.
All we see is our beautiful new website.
I finally figured out how to navigate it.
You're not the first person to say something similar to that.
Okay, so here we have the application. And I believe the commissioners can take judicial notice of this in the previous case. And if you want to take a minute, Mr. Rob, to review it, then I'll ask my question. Let me know when I should forward the document.
Okay.
Okay, so I'll ask my question again. Does the application in case number 20809 refer to reopening of case number 20580?
That letter doesn't, but I believe Mr. Bruce's statement, when this came up, did.
Okay, your answer is non-responsive. I'm asking whether the application refers to reopening of case number 20580.
I don't believe it says that.
Do you know, well, let me go now to, so would you agree that when Mr. Ragsdale received this application in the notice letter, that he would not be on notice that you were reopening case number 20580?
I believe Mr. Ragsdale testified that he would consider it a replacement well when he saw this application.
I think that's misrepresenting Mr. Ragsdale's testimony, and it's also non-responsive. My question is, wouldn't you agree that looking at this application, Mr. Ragsdale would not be aware that you were reopening case number 20580?
It doesn't state that on this letter.
It's not a letter, is it? Is it an application?
Sorry, the application.
Thank you. And then still on paragraph 6 in your self-affirmed statement, the last sentence, case number 20809 was heard on October 3rd, 2019, before the entry of an order in case number 20580. Do you see that?
Yes.
And there's been previous testimony about drilling before an order was issued. Do you recall that?
Yes.
And you've testified that there were lease obligations or assignment obligations that required you to drill before the order was entered. Do you recall that testimony?
Yes.
And what was the specific obligation that required you to drill before the force pulling order was entered?
If we didn't drill by a date, then we would lose acreage.
If you didn't drill by what date?
I don't have that date off the top of my head, but it was right around the time that we spud the initial well.
It was a term assignment with whom?
There were multiple parties.
You had more than one term assignment with a deadline that was expiring in July of 2019?
Pretty close. That was at least the first one.
And how long had Mewburn held these term assignments?
I'd have to check, but we've drilled 6 wells on these lands. I'm not sure of those 6 wells in 10 and 15 all apply to those term assignments, but we've had it for a long time.
Your answer to my question is, how long have you had these term assignments? Is a long time. Is that right?
Yes, because they had continuous development clauses, which means that if we keep drilling, we keep earning time to those. And as Mr. Cude testified, we drilled 3 wells in section 10, all but the east half where these wells are, and 3 wells in section 15. So a bunch of those term assignments were being kicked by the drilling of those wells, and the continuous development obligation was coming up.
And who at Mewburn made the decision to drill before the force pulling order was entered?
It was a Mewburn management decision.
And who constitutes Mewburn management?
A lot of people.
Give me an example.
Who our management is?
Yes.
Well, Mr. Mewburn owns the company. Mr. Waits is the president and CEO. Bruce Insulaco was the vice president of exploration at the time. There's a ton of people above me.
Okay, so it's your testimony that all of those people weighed into this decision to drill before the force pulling order was entered?
No, I'm not sure who all had a say in that. I was just explaining the Mewburn management, at least at the time.
Okay, and then still in your paragraph 6, it says it was heard, meaning case number 20809 was heard on October 3rd, 2019, before the entry of an order in case number 20580. This occurred after the drilling problems that resulted in the junked wells, correct?
Yeah, I believe so.
Turning to your paragraph 10, that's on the next page. You state here that Mewburn satisfied the pooling notice requirements of section 9.15.4.8. I believe that's a typo. It's 19.15.4.8. Is that correct?
Yes, that is correct.
In case number 20809, when notifying Mr. Ragsdale of the common source of supply and the area affected by the proposed wells. Let's take a look at those regs here. (19.15.4.8A4). You see the highlighted section there?
Yes.
So the application shall include the general nature of the order sought. And then 19.15.4.9 A6 further requires that the hearing notice published by the division shall include a reasonable identification of the adjudication subject matter that alerts persons who may be affected if the division grants the application. In your review of the application, do you believe that application actually alerts Mr. Ragsdale as to his to the fact that he would be required to pay the cost for those junked wells?
I believe that Mewburn satisfied all notice requirements of 1915.4.8. Yes.
That was not my question. My question was, do you believe that the application that we just reviewed would have alerted Mr. Ragsdale that he would be responsible for costs related to those junked wells if he participated in the wells that were pooled in case number 20809?
Like I said, I think we did all the correct notice requirements for this application.
So you're saying that the application we just looked at would have alerted Mr. Ragsdale to Mewburn's intent with respect to imposing those costs for the junked wells on the 1510 wells?
And it was the exact same spacing unit, exact same formation, exact same lateral length. With his experience, I would think that someone would infer that.
You're suggesting that Mr. Ragsdale should have looked at that application, and perhaps we should go back to it if I can. Hopefully,
Ms. Shaheen, I believe you asked the question no less than 3 or 4 times.
Right,
I believe the witness has answered it. You're welcome to ask it once more, but after that, I think we need to move along.
Okay, well, I just feel like I'm not actually getting an answer to my question, but if you want me to move along, I'm happy to do so. We'll go back to Mr. Robb's self-affirmed statement. I think it's here. All right. In paragraph 11, you refer to Ms. Anderson and her election letter under the JOA, which was January 23rd, 2020, and you refer to attachment E. And then you also refer to a similar letter that was sent to Mr. Ragsdale as attachment F. Do you recall why you sent that same letter to Mr. Ragsdale at that time?
Pull up these letters so I know what we're talking about.
Let's see if I can pull them up too. Attachment E. This doesn't have Ms. Anderson's name on it, but
she was part of the C attached list.
Okay. Okay, and then this is her certified mail. All right, and then here, attachment F is the letter that was sent to Mr. Ragsdale. And my question is, why was this letter sent to Mr. Ragsdale?
Because he requested it.
Mr. Ragsdale requested this letter?
Yes.
Do you have some documentation of his request for this letter?
No, but I remember it. I sent the letter to Tracy. She informed me that she had sold the interest to Mr. Ragsdale, and then I believe they reached out and asked us to repropose it.
You believe who reached out?
Miss Stanford.
Miss Stanford reached out to you and asked you to send this letter to Mr. Ragsdale?
Yeah, I was unaware that Miss Anderson had sold the interest to Mr. Ragsdale. They brought that to my attention, and I believe requested a well proposal under the JOA.
I'm going to stop sharing for a minute and pull
In
up.
Mr. Ragsdale's name instead of Miss Anderson.
And do you know when that sale was effective?
No, I have some. It's like it was after the wells were junked, probably.
Let's see, we have
I think Mr. Ragsdale might have a better.
a rebuttal exhibit here somewhere. I just need to find it.
Yeah, and it looks like in the last testimony, Ms. Stanford said that Mr. Ragsdale knew that the wells had been junked.
You know that I didn't ask a question, so you're referring to Ms. Stanford's testimony, which I've already made an objection to here.
Okay.
So
I was just getting back to
I
the
would ask
Tracy
for
Anderson.
you not to volunteer information if there's not a question pending.
Okay.
I'm having trouble finding this rebuttal exhibit. I circulated it to everyone. Yes. Oh, here it is. Found it. Okay. And now I'll share my screen again. Do you see this? Assignment, conveyance, and bill of sale.
Yes, I do.
And you'll see there in bold letters between Tracy Anderson, conveys and signs and conveys under Tom Ragsdale. Do you see that?
Yes.
And the effective date, do you see the effective date there?
June 1st, 2020.
So would you agree that Mr. Ragsdale didn't acquire an interest from Mr. Anderson until several months after this letter that was sent to him?
I haven't had time to review the title here. I don't even think I got a copy of this.
Well, we'll scroll through it here now. You want to take a look at it?
I'd like to see the entire chain of title because a lot of times multiple assignments are filed. I'm not sure if that's the case here.
Well, let's take a look at the Exhibit A. Maybe that'll be helpful for you.
I don't know whether to object or not, but what is the point of this testimony?
Well, the point of this testimony is that Mr. Ragsdale reportedly told them to provide him with a letter under the JOA, even though he had not yet acquired this interest. And I'm just trying to explore why. Sorry, I'm sharing a screen of my grandkids here.
I mean, if
and I'll ask if I have a question, I'll ask it. But right now I'm addressing Mr. Bruce's question.
He's testified that he was asked or told to contact her. What more is there to say?
I'm just asking for him to explain why, when the interest wasn't acquired until June of 2020.
I
The
can
letter was
touch
sent.
on this a little bit. If this is the case, then the interest that we credit Ragsdale to should actually be non-consent. So he shouldn't own that. Because Tracy Anderson never made a timely election. So if that's something I can look into that if you want. But the interest we have credited to Mr. Ragsdale is from Tracy Anderson, and she never made an election. Mr. Ragsdale did, because he told us he acquired this interest. If he didn't actually acquire it, like I said, I'll have to review the entire chain of title before making assumptions. But if this is true, then the interest we have credited to him is actually non-consent. If he didn't acquire it till June, but he signed the AFEs and sent them back within 30 days. So I don't know why he would do that. Like I said, I'll have to do some more research into the title chain.
You're saying that Ms. Anderson didn't elect to participate under the JOA? Is that your testimony today?
Under this specific election that you just showed me, or well proposal.
Okay, we'll go back to your self-affirmed statement. Oops, sorry. Turning back to the JOA, did you send the same JOA to all of the interest owners?
Yes.
And was that JOA the one that was proposed under the well proposal letter for the 1,280 acre unit?
Yes, the JOA was 2 sections. 10 and 15.
Was there a well proposal and a JOA that pertains specifically to the spacing unit that was ultimately force pulled?
No, that's what the order is for.
So there was no opportunity to participate under a JOA with respect to only the spacing unit that was ultimately force pulled. Is that right?
That's incorrect.
So okay, I'm a little confused. Are you saying there was a JOA that pertained only to the east half of sections 10 and 15?
There was not a JOA, but you asked if there was an opportunity.
Was there an opportunity to participate in a JOA that pertained only to the east half of sections 10 and 15?
Mr. Ragsdale never asked me about one. We might have been able to work something out, but he stated that he will never sign another JOA with Beburn. So, and he made that well aware to us.
Excuse me. I'm going to object because you're non-responsive. You're not answering my question. You're answering the question. My question was, did you provide an opportunity to anyone to participate in a JOA that pertained only to the east half of sections 10 and 15?
I did not put that together. I sent the 2 section.
Thank you.
I would like him to fully respond to the question.
The question was a simple yes or no answer, and he gave me the answer and additional information I have not requested.
Mr. Bruce, if you're interested in a full answer, you can ask on redirect.
Nah, I'll skip that. I've got a few other questions, but I won't take the commission's time right now.
I'd like to turn now to the AFEs that we looked at earlier with Mr. Cood. You recognize this AFE, Mr. Rob?
Pull it up. Where's this at? Is this in yours?
This is, yes, it's part of Exhibit 3 attached to our pre-hearing statement and.
Yeah,
Mr.
it's just
Rexdale's
kind of hard to
testimony.
read on the screen.
I can make it bigger.
I've got a copy. Somewhere. But you can continue. I'll find it.
Okay, so this is the AFE for the 1510-2H that was submitted to the division. Is that correct?
Could you scroll up? I'm still trying to find it in here.
Excuse me. It's attached to your affidavit in the previous case, the 20580 case. And that was Exhibit 3.
It's an AFE. Which exhibit is this?
Exhibit 3.
Oh, sorry. There's exhibits within exhibits. I'll just look at it on here. Okay, keep going.
Okay.
Sorry.
Do you want me to scroll down?
Yeah, it might have to be a little back and forth, but
Yeah, and then we're going to go to the other AFE, so it'll be a lot of back and forth. So here's the date on it, September 10th, 2019. And the total well cost, 9.389 million. Do you see that?
yes.
And why do you assist in putting together these AFEs?
No.
Do you review them before you attach them to your exhibits in the cases?
As they pertain to land matters,
Were you aware that that did not include the cost for the junked wells?
yes, that was our AFE for the costs moving forward on that particular well.
And why didn't you include the cost of the junked wells if Mewburn intended to charge those to the parties who were forced pulled?
I'm not sure if we even had the costs at this point.
Well,
But
you would have had your daily drilling reports, right?
our costs don't come in on our costs through vendors don't come in on the drilling reports.
Your estimated costs aren't revealed on the drilling reports?
I thought you were asking about actual costs.
Well, the actual costs of the expense, the anticipated costs of the expenses as they incurred are included on your drilling reports, aren't they not?
I'm not sure what that number is, if that's bills to date, because I know bills don't come in. We don't get bills every single day as we're drilling.
Right. Well, you would have, the wells were drilled in July, right?
Yeah, sorry, we can move past that part. You can continue with the question.
So you would have had some idea of what the costs were a couple months later, correct?
I'm not sure.
You don't know whether you're aware of what the costs were for drilling 2 months prior to submitting your AFE?
That's not in the landman's job, is following drilling costs.
Is that something I should have asked Mr. Cood?
Yeah, I mean, he does reservoir here. I'm not sure if he tracks the daily cost, but
Because if I recall correctly,
I definitely don't do that.
if I recall correctly, he deferred to you when I was asking him questions about the AFEs.
Okay, I can tell you this does not include the actual drilling costs. This is our estimate of costs moving forward for that well.
And why didn't you include those costs for drilling the junked wells?
I feel like I've answered this like twice now.
Okay, well, one more time and I'll move on.
Because it was the estimated cost of the well moving forward.
Okay, so you would agree that an AFE is for estimated cost?
Yes. It's an authorization for expenditure. It typically lists estimated costs.
Okay, we're turning now. This is in exhibit 4, excuse me. This is in exhibit 5. I believe it's attached to the election letter that was sent to Mr. Ragsdale.
Okay.
And you can see at the top, this is again the 15102H. And if you scroll down, you'll see the date here is March 2nd, 2020. And the total amount has increased by approximately 3 million. Previously, the well was estimated to be 9.5 million. And here it's closer to 12.5 million. Do you see that?
Yes.
And what is the difference between this AFE and the previous AFE?
If you scroll to the page directly above this, it tells you everything included on that AFE. And reading this, about 3 lines down in the second paragraph, the AFE is an estimated well cost for the captioned well and the realized cost of drilling, plugging, and abandoning the IBEX B1 AP FedCom number 2H well and the substitute IBEX 1015 B1 AP FedCom number 2HY well, which was drilled in accordance with 1915-13-8, paragraph 4, NMAC.
Excuse me. So would you agree
I
that?
know
if
you're
Mr.
reading from this stuff, but please, you have to slow down. I have not a clue what you said. I have the exhibit. I'll get it from the exhibit, but everybody's tired. Everybody's speeding up. And
Yeah,
this
I
makes my
apologize.
job miserable.
Yeah, I apologize. I thought about that halfway through.
So turning back now to the AFE, and at the bottom here, it's prepared by L. Jackson. Do you see that?
Yes.
And Mr. Cood previously testified this is Levi Jackson. And I asked the question, I believe he deferred to you, who instructed Mr. Jackson to include those costs for the junked wells in this AFE?
I believe this was also a management decision.
So that would include all the folks you identified previously?
Some of them, most likely. But after reviewing the OCD's rules, I also believe that this should have been included.
Ms. Shaheen, I just want to jump in real quick and do a time check. I know the court reporter's been going, we've all been going for a little while at this point. Do you have an estimate as to how much longer your line of questioning will take? And it kind of, your answer will dictate kind of when we take a short break.
I am going to estimate that I have about 10 minutes, and then I'd like to confer with my client before I conclude my questions of Mr. Robb, if that would be acceptable.
All right, let's go ahead and go for another 10 minutes and finish up your questions, and then we can take a break while you confer with your client.
Thank you.
Actually, just to check, Ms. McFarland, are you okay at this point? Do you need a break now?
No, thank you for asking. I'm fine. It just, when people read, it makes no sense anyway, because they sound like robots, but as they get more tired, it gets worse. So thank you.
That's fair. All right, please proceed, Ms. Shaheen.
Thank you. Going to paragraph 15 in your self-affirmed statement, and I'll go back to that now. You state, in my experience, a pooling order is the equivalent of an operating agreement. Do you see that? What do you mean by that?
There are two governing documents that we operate wells under. As an operator, it's either a joint operating agreement or a pooling order are the means that we can recoup costs and distribute revenue and everything to operate a well.
And why is the pooling order equivalent to an operating agreement?
It's the governing document that we operate under.
And
the NMOCD version of it, I guess.
And Mr. Ragsdale is not subject to the JOA, correct?
Incorrect.
Oh, well, let me say this. Mr. Ragsdale is not subject to the JOA with respect to the interest at issue in this proceeding.
Correct.
And so would you agree that the JOA has many, many additional provisions other than those that are provided in, for example, the order that was issued in 20809?
Yes, it's much longer.
So when you say Mr. Ragsdale has not been treated any different than the interest owners subject to the JOA, should he be treated the same as interest owners subject to the JOA?
They say slightly different things. I guess it depends on the situation.
Well, give me an example of what you mean. They say slightly different things. I mean, you just testified that there are many more pages in a JOA. I believe the order is 7 pages.
For example, in a pooling order, you're required to prepay the estimated costs when you receive, or under the pooling order, you're required to prepay the costs. Under a JOA, you are not in most circumstances.
So that would be a difference between the two, correct?
Yes.
And here again, we talked before about how the JOA actually covers the 1,280 acre unit and not the east half of sections 10 and 15, correct?
Correct.
Excuse me, Madam Chair, at this time, if we want to take a short break, I can confer with my client and come back and finish up quickly any other questions that we have for Mr. Robb.
Okay, it is 3:48. Why don't we come back at 3:55? So 7 minutes.
Thank you.
Okay, just to make sure I understood that, you have more questions for Mr. Rob or Mr. Coon?
For Mr. Rob, they were questions that Mr. Cood deferred to Mr. Rob.
Got it. Mr. Rob, are you ready?
I am.
All right, go ahead, Ms. Shaheen.
Thank you. Mr. Rob, do you know of any instances in which there's been a similar circumstance for Mewburn where there's been failed attempts to drill and those costs have been subsequently imposed through an order that was entered after the failed attempts to drill the wells?
Yep.
And when the drilling issues occurred, did Mewburn confer with its partners about next steps?
With our JOA partners, yes.
Did you reach out to any of the parties that you were attempting to force pool?
No, we are required under the terms of the joint operating agreement to do that. The terms of an order does not require that.
Well, there was no order, correct?
I had done a ton of pooling cases around this time, and no order that I've seen before that or after ever states that.
Well, wouldn't you be required to share that information with a party who elected to participate under a forced pooling order?
I've read the order and I don't see where it states that.
There, again, there was no order at that time, but
Every
when
order
there,
before and after that I've seen, I have not seen that requirement.
if I understood correctly, your previous testimony, you said that you shared information with parties under the forced pooling order who elected to participate. Is that correct?
Yes.
Okay. So.
Who elected to participate?
Right, but there was no order, so there was no opportunity for the forced pooled parties or the parties you attempted to force pool. There was no opportunity for them to elect to participate. Is that right?
No, I sent the forced pooling order with the proposals, and then I sent all the well info to the parties who elected to participate under the order.
I think we're talking about two different time periods. I'm focused on the time period when the junked wells, when you drilled the junked wells, and there was no order at that time, correct?
Correct.
And you did not share any information about the junked wells with the parties that you were intending to force pool at that time. And in fact, we're in the process of force pooling, correct?
They were not entitled to information, so no, I did not send that. They were not participants with us at the time. Once they become participants, then we share the info.
And isn't it true that they couldn't become participants because there was no order? Is that right?
I object to this. This has been asked and answered about 6 times today. Let's move on. Let's get the hearing over with.
They could have signed the JOA and then elected to participate. So yes, they had an opportunity.
Mr. Bruce, I think Mr. Rob answered the question, but Ms. Shaheen, I think
That's fine. Thank you, Madam Chair.
Mr. Rob has answered the question, so we can move on to the next.
Yes, that may conclude my questions. Just one sec here. No more questions for Mr. Rob. Thank you.
Thank you, Ms. Shaheen. All right, commissioners, do you have questions for Mr. Rob?
Yes, ma'am, I do. Rob, so I do have some few questions for you. Now, the first one, I just want to understand this clearly. So I want to know, from your perspective, what is the significance of the JOA and the force pooling to our oil and gas industry?
They allow oil and gas to be developed. Without the two, everything would just be handshake deals. No one would be held accountable for cost. We wouldn't be able to have a means of distributing revenue. It would definitely hinder development without JOAs and pooling orders.
Now, would you recommend companies going ahead, without receiving pulling orders, to drill, to embark on drilling? Would you recommend companies to do that?
Everything's circumstantial. In a perfect world, it would be best to have all parties signed up under a JOA. In a less perfect world, it would be JOA and pooling order.
No, but I'm asking.
Sorry.
Go ahead. Sorry.
But in our case, it was a little different. We knew the regulations. We knew what we were doing was legal. We had 90% of the people signed up, and of those 9.4, I believe, that were under there, a bunch of those parties had communicated to me that they wanted to participate under the pooling order. So our risk was, it wasn't like we're risking 100%. It was Mr. Ragsdale's piece and maybe some smaller other pieces. So we took that risk in order to save our term assignments. So most of it was tied up under the JOA. So we took that risk knowing that the pooling orders can still be issued after a well's been drilled.
Okay. Now let me ask you. So you talked about where there was no consent, or more or less there was no Mr. Ragsdale did not contest the cost. He did not contest the cost because he did not, you guys did not, or let's say Melbourne did not receive any official communication, whether through phone calls or let's say through emails, to assert that. Now, my question to you is that why would you also want to say that Mr. Ragsdale knew about the junk wells where there was no official communication to him, but you are certain that it is probably through a third party? So why would you also assert the same thing?
His Miss Stanford stated that in her last testimony, that she knew about the wells. I know it's Miss Stanford, and we've already talked about that. I spoke with Tracy Anderson on numerous occasions. Every single time we junked the wells, and she wasn't super familiar with oil and gas, so I was explaining a bunch of that to her. And I was under the impression that she was in communications with Mr. Ragsdale or Miss Stanford.
Yeah, but so I think you wanted to make it more clearer to us that he did not contest. And according to his testimony, Mr. Ragsdale also talks about he didn't know about this, So I'm just trying to draw the line here that if you are saying that Mr. Ragsdale did not contest the cost because there is no substantial evidence in terms of calling or let's say writing to prove that, why would you also believe, because I didn't get the answer from your statement, how would you also believe that he's saying he didn't hear about it, but you are saying he heard about it, and your justification is that it's from a third party? So how would the commission agree with what you're saying other than not agreeing with what Ragsdale is saying?
I mean, we're two people saying two different things. He knew about the cost when I sent the proposal to him, because it was stated on there.
Let me ask.
It wasn't just an escalated AFE. Then he had no idea why. It states on that letter that I sent him why those costs were escalated and what provisions we were applying those costs under.
So based on Melbourne's practice and also the practices in the industry, do you usually receive orders, let's say force pulling orders, before proceeding with the drilling?
Nowadays, the process has become a lot more smoother. and orders get pushed out a lot quicker. When I first started it was sometimes over 6 months. Now it's a week or two. So if we would have had this hearing today, we would have the order before we would have drilled. That's no fault of the OC. I do like how everything has changed, but we don't know, at that time, we didn't know how fast the orders were going to be issued. It took about, I think, 4 months. So it all depends on, like you said, it was about a 5% risk to us that wasn't signed up, that we would have to clean up later.
So are you saying that there were instances, let's say with Meborn, where they've gone ahead to drill or perform an activity prior to receiving a false pulling order?
Yes, we did that.
No, I'm saying that have you done that before? So not just with this case, but has that happened in the past where
Oh,
they
yes.
did not receive the order, but they still went ahead and do it prior to the
Yes.
issuance of the order?
Yes. Like I said, when I first started, they took sometimes 6 months to get issued. So we were definitely drilling without orders then as well.
Okay. So, I also want to know, so there are two laws that back in each other's claim here. So I want to have your take on how would you view the substitute rule? Because that one I saw pursuant to order, right? So before you can assess the cost, it is pursuant to order. So then, from my understanding, I understand that you need to have the order first before you can more or less talk about a substitute. Now, Mr. Bruce also brought out another issue where he feels that, like you're saying, you don't necessarily have to get the order. You can go ahead and drill prior to the issuance of the order. Now, I want to have your take to compare these two and tell me what you believe.
Okay. Sorry, so I don't think that we need an order to drill because I believe that provision is part of the Oil and Gas Act, not the orders themselves. In terms of substitute wells, let's see, is that in the orders as well? Mr. Bruce might be able to confirm what I'm about to say, but I don't believe that it speaks to substitute wells in the orders themselves. It's in the rules and regulations.
I'm not sure, but let me move on. So, in Mr. Rasdal's testimony, he talked about on page 5 of his testimony, he talked about the phone call between yourself and then Ms. Stanford. And
Yes.
in that, he talked about you advised Ms. Stanford to talk to Mr. Bruce. But based on your testimony, it sounds to me that never happened. Can you confirm that?
The way he described the events was not how it went. Like I said, we talked for at least 5 minutes about the issue at hand. She did not call, and then I said, you have to talk to Mr. Bruce. We explained everything, talked about it. That's when he was just reading what was written on that letter.
Okay, sorry.
Which in this case, I'm actually the one that said it. So I feel like I have a better knowledge of the events than Mr. Ragsdale.
My next question is on the AFE. So when did Meborn decide to add the additional cost from the junk wells, to the AFE? And then why did Meborn not notify the OCD about this in that particular application?
So if you look at the previous order, I believe Mr. Bruce actually touched on this in case 20809 when he presented it, which is on page 5, paragraph 32. So at the case, he did present that to the OCD, what our objective was.
So are you saying that Mayborn actually notified the OCD about including the new cost as part of the new AFE for the substitute well?
We notified the commission of our issues and our plans to drill from the south to the north. But I don't know if I don't think we were required to let the OCD know that we were including these, because we were under the OCD rules, we're allowed to drill substitute wells.
Yeah, but you say that you don't know, you are not aware. Like, let's say you're saying that you were not supposed to notify OCD that you're going to impose that cost, you know, as part of the substitute well. You were not supposed to do. You don't necessarily have to do that. Is
Well,
that
there's rules and regulations that state we are allowed to drill substitute wells. So with those wells and with those rules and regulations in place, we didn't see the need to notify the OCD since it was allowed to do and to impose those costs. That's in the rules as well.
okay? But during that application, you still submitted AFE.
Yes.
So then why did you not disclose that on the AFE? Because Mr. Rasdell is saying that you did not, Melbourne did not add that cost to the new AFE. That is why he did not appear to contest, right? So
sorry.
So I'm trying to understand, if you want to be in good faith, why did you not just add it to it and say that this is a substitute well, and this is the new cost, because you are allowed to recruit your cost, and I'm adding it to the new AFE.
Yeah, so when we provided notice, the AFEs weren't part of that. Those came later on when we presented the case. And we were presenting the case of this is the cost of these wells moving forward. We had encounters, we had problems drilling the first two. Mr. Bruce stated that at the trial or case trial. And by the time when I submitted all that, I personally did not know the total costs that were incurred from those first two wells. So we just included the costs of the well moving forward.
Yeah, thank you, Madam Chair. No further questions at this time.
Commissioner Bloom, do you have questions for the witness?
Madam Chair, no. Our Commissioner and Pawan certainly covered everything I was going to ask. Thank you very much.
Thanks. So I have some questions. There's still redirect for Mr. Bruce of Mr. Robb. I think, do we want to, Mr. Moander, talk about schedule right now before I go into questions?
Madam Chair, I think that might be a good idea because it is my sense that this matter is probably not going to wrap up completely today. Not sure whether witnesses will be taken care of, but at this point, I think we could start with availability tomorrow morning to get this finished. Because I understand, Madam Chair, that you've got obligations in the afternoon, as do I. So I think, yeah, let's have a talk about that.
I think there is a chance that we can finish up with witnesses today. Closing seems more realistic tomorrow at this point. and then there's still deliberations. I don't think we've closed the door on recalling potential witnesses from before. So depending on that piece, and if the commission feels like that's necessary, that I guess would need to be tomorrow as well. I can be available tomorrow morning, the majority of the morning. Greg, I know we had something tomorrow, I think at 11. But I could punt that to other people on the call if necessary and go from like 8:30 to 12:30 if necessary, but that's about the max for me.
I mean, I will not be available after 12.
Okay.
So that'd be a hard for us.
Commissioner Bloom and Dr. Mpoma, what do your schedules look like tomorrow?
Madam Chair, I could do, from whatever time in the morning, 8 to noon as well, or even go up to about 12:30. But with Mr. Moander's limitations, 8 to 12 would work on my calendar.
Dr. Mpoma?
Yeah, I can be available 8:30 to 12.
Okay. All right, Mr. Bruce and Ms. Shaheen. What about your schedules tomorrow morning?
I'll ask my client, if mainly Mr. Rob, if he's available, but I am available anytime the commission pleases. My follow-up with Mr. Rob is about 3 questions long, but I would ask Mr. Rob and Mr. Q to talk about their availability. I haven't had a chance to talk with them.
So we're
Can I
We're
just
good
check
whenever
if this is
tomorrow.
on the record or not? If you,
I
if you
think
wanted
it's
this-
on the record,
I think
right?
it's on the record.
Yeah, it
Okay.
is.
Okay,
We're good at any time tomorrow.
Ms. Shaheen, what about your witness if necessary?
I actually, let me try to. Mr. Rexdale, are you on now?
Yes, I believe so.
We can hear you.
What is your availability tomorrow morning?
Well, I'm in Santa Fe at your office, and I missed my flight today, but this is very
Sorry.
important to me. No. It's a lot of money at stake for me personally, a lot of money. So you got my complete availability. The commission has my complete availability to wrap this up and do it right.
Okay, so it's sounding like everybody's available tomorrow morning from 8:30 to noon. What is the process, Mr. Moander? Do I just need to send a WebEx to Ms. Davidson and Ms. Davidson get?
That's it. We'll let me check one thing here and we'll get this on the record properly. My apologies here. I'm even a little fried.
Madam Chair, if I may, just for a minute, you raised a number of questions regarding research. And I'm wondering if it might be acceptable to the commission for us to do our closings in a written form. For example, after we get the transcript. I don't know if Mr. Bruce would be amenable to that, but that might save us quite a bit of time tomorrow if the parties agreed to written closing statements and if the commission was amenable to that.
Ms. Sheen, when would you anticipate having those filed? Because if what I'm hearing would be that the party council would be working on this and submit tomorrow morning or late this evening. Is that what you're thinking?
Oh, no, I was thinking more along the lines of after we get a transcript and have some time to research the issues that Madam Chair raised, that we would submit closing statements a little ways down the road.
So, Madam Chair, admittedly, this case seems like it's unique from some of the other issues the commission has dealt with. I know you have a preference for being pretty decisive. There may be some value in considering that. Given that it seems like there's been requests for a lot of legal authority, that, putting it bluntly, no attorney at this meeting has either had luck finding or the issue doesn't appear to have been anticipated. So I think that there is value in that. I'm not saying that there is a correct answer here, but from a standpoint of, as Mr. Ragsdale said, getting it right or getting it done right, I think there's merit there.
So just thinking out loud, if we were to do that, would we need tomorrow morning? I guess depends on if we need to recall witnesses.
That's probably the extent tomorrow, because what would happen, I would anticipate under those circumstances, is then you would close the evidentiary record. And then at that point, there'd need to be some discussion about when to continue this for deliberation, because under, let's see, it's wait, I've got the wrong. Oh yeah, 1915-415, the adjudication rules for the OCC. The commission can continue this hearing so long as the commission identifies on the record the date, time, and location where the hearing will be reconvened. And we don't need to post notice, but that's also making some assumptions about, for example, timeliness of a record being produced, or the transcript being produced to the parties, and as well as the commission. So that would be a decision that we'd have to be very clear, or the commission would have to be clear about that.
Commissioners, or I guess Mr. Morinder, at this point, can the commissioners discuss whether or not we believe we need additional testimony, or should we wait?
I think that there's nothing wrong. Well, why don't my suggestion here is let's finish with Mr. Rob's. At least it'll be. Are we on redirect now?
Nope, I got questions.
Okay, so I think we need to at least try to get. Well, it's almost 4:30, and so I think now we probably need to make that call, because I think that's 4:30, sort of the witching hour where these decisions need to get made. So discussion about that now would not be inappropriate.
Okay. Commissioners Bloom and Ampoma, do you have additional questions at this point for either Mr. Ragsdale or Mr. Rob? I'm sorry, Mr. Rob is up. Mr. Cude?
Madam Chair, I do not. And one other thing that occurred to me is, do we have a court reporter for tomorrow?
Oh yeah, that too. That's important.
Good question, Commissioner. Thank you.
Ms. McFarland?
Yes, I'll make sure that somebody's there. I'll probably be here, but I'll make sure somebody is there. Just you have to give me an accurate time.
Okay. Good thought, Commissioner Bloom.
But no, I do not have further questions of Mr. Ragsdale or Mr. Coote at this point. I do not anticipate that, but see how things go as we wrap up.
Dr. Ampoma?
I do have some questions, but probably I guess I can wait tomorrow. I don't need to ask Mr. Ragsdale today, but there's only one question that I have for him.
So it sounds like you might have more questions for Mr. Ragsdale tomorrow. Okay. I probably have a couple more that might be helpful. Just trying to line up all of the pieces. So it sounds like tomorrow is probably necessary. Let's see if we can get through Mr. Rob today. And then we will come back tomorrow at 8:30 virtually on the lovely WebEx platform. And recall any witnesses and then determine what's most appropriate for closing. Does that sound like a plan?
I think that's
That
reasonable.
sounds fine to me, Madam Chair.
I know we all wanted to spend day 2 together, so. All right, great. All right, well, Mr. Rob, One of the things I don't know if we've discussed at this point is whether or not the additional rig costs are appropriate. The cost for the junk wells are appropriate. We've talked about whether or not they should have been included in the AFE and whether or not that was appropriate, but not really about whether or not that, I think it was around $3 million was the appropriate. Is there any information that you could provide the commission regarding those additional costs surrounding if $3 million was appropriate to plug and manage those 2 junk wells?
Yes, so for those 2 junk wells, I believe those are reasonable costs. So is that it?
Why?
I mean, are you asking if should have we kept drilling in that same side, or?
No, what I'm asking for is, and maybe this is more appropriate for Mr. Cute, but are those reasonable costs to have plugged and abandoned those wells and moved the rig and all of those pieces for those 2 wells before moving to the 1510s ultimately? I mean, basically what you're saying is it costs around $3 million. We're passing this off to the parties. But I haven't heard anything regarding, like, was the $3 million, what made that cost appropriate?
So I don't deal in costs very much, but I do deal with all of our partners, and not one of our other 50 partners outside of Mr. Ragsdale brought up an issue to this. Brought up issue to our costs. They deemed everything reasonable. They paid for those costs through the JIBs. So that's, I think, the best that I can answer it is none of the other parties brought issue to this.
Are there any, I'm assuming, or I guess, has Mewburn, it sounds like in the past has had to occasionally junk wells, correct?
This was not our first ever, no.
Do you have costs from those situations that would be comparative to demonstrate that these were appropriate costs?
That's kind of a tough question. Like Mr. Cute said, we try not to make a practice of it. So the few that we have had to junk, I don't know exactly where in the drilling process we did junk those. So say if it was at 400 feet, that would be less expensive than ours because we drilled a lot deeper.
Okay, maybe it's more appropriate for Mr. Rob tomorrow. I'm sorry, you're Mr. Rob. I'm like totally thrown off by the name thing now. Mr. Cute.
Madam Chair, this is Jim Bruce. I think it's more appropriate for Mr. Cute, but you know, if we're going to do a written closing, perhaps, and Mr. Ragsdale might want to do this too. If it can't be done by tomorrow morning, perhaps submit a supplemental affidavit if we can find those costs, along with the written closing.
Okay. Yeah, what I'm trying to understand is, are the costs appropriate? The applicant is asserting that they're not. Okay. What portion of the $3 million would have, I just want to understand how this works. So if the cost, so it's now $12 million, there were those parties that were listed on the document Ms. Shaheen put up. Does the cost get distributed based upon their ownership percentage?
Yes, so the well was $12 million. On that exhibit we looked at earlier, it had the percentages of every owner. Mr. Ragsdale's was 4.89, some change. So his share of that would be the $12 million times the 4.8%.
So around 580,000-ish, 585 maybe. Something like that. Okay.
Yeah.
And the way that can be paid is either through production, like payments, once the well starts making money, it could be paid through that, or an upfront cost.
Yes, so he's required to pay pursuant to the order. I believe this one has changed a few times since I started. He has 30 days to sign the AFE, and then once he signs the AFE within that 30-day period, then he can prepay his estimated share of those costs. But in this case, he never elected in the first part, so the second part kind of doesn't apply.
Okay. I know there were a lot of questions about this earlier, but I feel like I never got a clear answer. Did any of the other parties object to the junk cost addition, the change from the 9 to the 12?
No, none of the parties did.
Okay. So I think we established that for both cases, I don't have the numbers off the top of my head. Then case number what was it, 20580, which was the 1015, and then in case 20809, which was the 1510. So normally, like for a standard compulsory pooling application, where it's the first one, like it's the first notice, I guess maybe for example, like for 20580. What is the normal notice process for the parties? Can you walk me through that?
I guess starting at proposing the wells.
Yes.
So typically I'll find out who the owners are, and then I'll propose them wells, send a copy of our joint operating agreement, speak with the parties throughout the whole process, and then we'll apply for the pooling hearing. Then that notice gets sent to all of the parties. And then a pooling date is set. We have the hearing. Can we keep going?
No, I think up until that point is good. So I believe in Mr. Ragsdale's testimony earlier, he noted that he did receive the notices. What I'm trying to understand is whether or not how a party or an owner would know that they should participate based off of the notice. And an initial notice, is it just, you know, like land, some sort of section township range indication, and based off of the section township range and information, plus the fact that you got notice, you should understand that that is something you might want to participate in. Like, I'm trying to understand how parties should know that they need to be involved and it impacts them.
Yeah, so the notice, it typically lists the applicant, his address, the common source of supply, so the bone spring formation, the areas affected, which in this case was the east half 10 and 15, and that we were seeking to pool it. The notice doesn't require all of the stuff that we put in the exhibits. And someone with Mr. Ragsdale's experience would most likely know that we were drilling wells in this operation unit and formation based on the notice and just his experience.
Okay, so even if it's somebody who is unfamiliar with the oil and gas industry, the information, one, that because they received a mail notice, and two, because the legal notice for the hearing contains that it exists in section township range, et cetera, that they own property in or minerals, they should understand that they need to participate, or they might want to participate or pay attention.
Yeah, so the notice just notices them of this hearing that they have an interest that is uncommitted to our unit, or to a unit. It doesn't give them any economics, or we don't tell them, hey, you should participate in these wells. It just gives them notice of the hearing, the formation, spacing unit, what's going to be drilled. But we don't tell people if they should participate or not.
Okay. And then I think what Dr. Impoma, some of his questions and some of Ms. Shaheen's questions, were trying to elicit as to whether or not you received any such objections by any parties for the cost. So, but you, just to confirm, like formally in the orders, like for order 2094, I think it's condition 12. So when you say you didn't receive any objections, you're saying you didn't receive any objections pursuant to number, what, 12, I believe it is in the order?
Sorry, I'm looking at the wrong
It's okay.
exhibits. Yeah, I never received a formal objection or any objection.
It's so it on. So walk me through this process because it almost reads here like if no objection to the actual well costs for any well is received by the division. Are you familiar? Okay, let me take a step back. Sorry. Have you been through a process where you have gotten an objection to the, like a formal objection to the costs?
Yes, Mr. Ragsdale objected our IBEX 10 B3 NC FedCom number 1H well, I believe, which was the well drilled 2 spacing units away from the one at this one at question.
So what does that look like? What does that process look like when there is a formal objection that's received?
I'm trying to remember, this was 3 years ago. So we have a hearing, and in that hearing, the OCD determined that our costs were reasonable against Mr. Ragsdale's objection.
Can you walk me through the front part of that, the receipt of the objection piece? Is it the division that receives it? Is it the operator that receives it?
Yeah, I believe y'all received the objection.
So in order for it to be a formal objection, it has to be to the division?
I believe so.
Did the division receive a formal objection within 45 days?
Oh, sorry, I was talking about the old well that he objected the costs on.
Right. I'm trying to understand the process and understand like how that for this well, did an objection get filed to the division?
I believe the last case was to declare an unreasonable certain costs. And that was ruled against. But I'm not sure. Off the top of my head, I'm not sure if y'all got that.
But not for the original case, the 20580. That would have been in 20809.
Yes, yeah, so 2809 superseded 20580. And it's, let's see, paragraph 17, so this order supersedes and replaces order number R-20924.
Okay. I think that's all I have for the moment. Mr. Bruce, or I'm sorry, commissioners, do you have any additional questions? No? Okay. Mr. Bruce, do you have any redirect for the witness? We can't hear you if you're speaking.
Whoops,
There
sorry.
you go.
I basically have 3 questions just to address a couple of things raised by Ms. Shaheen, if I may.
Please proceed.
First and foremost, before I forget, I have talked with Karen Stanford, but only at the prior hearing in this matter. She never called me about the well costs. I just want everyone to know that. Mr. Robb, when Ms. Shaheen was asking you about the number of parties, working interest owners in the well unit. In your exhibits on interest ownership, you agglomerated Mewburns and all of the other people who signed the JOA in that 90% figure, correct?
Yes, correct.
So even though you force pooled a number of parties, that does not, whatever that number was, 10, 12, 14, that does not include all of the other working interest owners who joined by signing a JOA.
Correct.
And then she asked you, I believe, whether or not there was a separate JOA covering this particular well unit, and I don't know whether there is, but just in general terms, do a lot of JOAs cover more than one well unit?
Yes, most of the JOAs that we have cover more than one well unit.
And now Mewburn isn't averse to having a JOA for one well unit, but that's not necessarily what occurred here.
Correct. And no one requested a JOA after I'd sent the original one that only covered the east half, or the spacing question.
Thank you. And then finally,
Sorry, I missed that. That covered the east half,
spacing.
east half, or the next.
Or the spacing unit in question.
And then finally, this situation is, you've never been involved in a situation like this, is that fair to say?
Correct.
But final well costs, in many instances, due to various contingencies, may well be higher or lower than AFE well costs. Is that a fair statement?
Correct. They're very fluid.
And it just depends on what happens during the drilling of the wells.
Yes.
That's all I have, Madam Chair. Thank you very much.
Thank you. All right, at this point, I think we break until the morning, or continues the term until the morning.
Use the correct term, Madam Chair.
Great. And we will reconvene at 8:30.
And Madam Chair, if I might ask this of you as well as the parties, if we can get everyone roughly available about 5 to 10 minutes before we start so we can maximize our time tomorrow since we've got some hard stops. I think that would be a good idea. That's just my recommendation for case management purposes, Madam Chair.
That's fair. Okay, so I will create a new WebEx. I will send it to Ms. Davidson, and then the lawyers and the party expect another panelist invite from me tonight. Well, and the commissioners, et cetera, expect another panelist invite from me tonight. And we will see you in the morning.
Have
Anything else we need to do, Chris? Or is it like, are we good?
That's it.
Okay.
We're done. We're continuing the hearing. The end.
All right. Thanks, everyone. Have a good
Thank
evening.
you.
Can you hold
You
on 1 second, Madam Chairman?
Yep.
Just in case it's 4, well, what time is it with you? 4:50?